Any original side mentioning? Listed matter for judgment. Item number 1, Swiss Singapore India Private Limited versus Bellisti Company.
Sorry.
No, it was expected.
Accordingly, GA number 1 of 2023 is dismissed on contest without any order as to cost. Order dated such and such, appointing an arbitrator, affirmed. I need not say this, but it remains.
My learned friend had already scared me early in the morning.
No, I had said.
At this stage, all of you will be knowing at least anticipating the fate.
Yes, I told him.
He tried his level best. He started very well. I was convinced at the beginning. Before you opened your mouth.
May I read the judgment if your lordship permits me?
Mr. Lal, I generally don't do that.
I'll tell you the reason why, because the website is giving a little technical glitch.
Oh, then
so I'm not able to download any orders.
Then yes. If some difficulty like this arises, please just inform me.
There's a technical glitch, Millard, on the
No,
website.
then
for the last 5 days, no orders can be downloaded.
Because the central server is down.
The cause list also cannot be.
No, it cannot.
Somebody
The central server is down.
Oh, everything is.
The Honorable Chief Justice was saying in a matter yesterday that he's spoken to them and
definitely.
Normally, I would not have asked.
না cause list সবসময় দেখা যাচ্ছে না
দেখা যাচ্ছে না
সবসময় হচ্ছে না
Millard, I would normally not make this request.
No,
দেখতে দিন now that the matter is over, Millard, Mr. Lal, very very nice of him, he had agreed to appoint a senior person, but
I had, Millard, I certainly had, but when I got back to my clients, Millard, they expressed their
in
reservation.
fact we had agreed on the personnel also.
the difficulties in these
No,
matters,
I know, Millard,
if
I
it is
know.
done, that will set a very bad example.
I know.
And no arbitrator will ever
No,
be.
correct, Millard, as a
Everybody will be
correct,
insecure.
Millard,
Then.
as a professional.
And at that point of time, it was if it was pointed out, then I can appreciate the agony. But even then, I think this will set a very bad example.
No, that's why, Millard, in fact I started by saying
I
that's
know
the
that.
embarrassing
Yes.
part.
You indicated just.
Yes,
Grateful.
man.
Item number 2.
My lord, Mr. Banerjee is appearing, Mr. Shatru Banerjee, my lord, asking for praying for short passover, my lord.
Well, then I was given leave to file a supplementary affidavit. It looks big, it's just the agreement. It's only 2-page. May I file that? Then maybe come back on the reopening.
Yes. Gladly.
Because
You're for the petitioner.
I'm for the petition.
We got served only two supplementary.
Oh, one is my copy.
Code একসঙ্গে থাকে।
And also, my lord, that here also we are asking for change of arbitrator. So I think after your lordship's comment, I was very reluctant to even
No,
start.
the ground for change in the previous matter was something else.
We were hearing that.
So if your ground is the same, Mr. Ghosh, then you are in difficult. Let us hope for the best after the vacation. The bench changes and all. The best for your client. Anyway, the supplementary এই তিনটে matter একসঙ্গে হবে, supplementary affidavits filed in court today be kept on record. Stop. On prayer of learned counsel.
And the third one, we haven't filed a supplementary because that your lordship has appointed that common Rajashri Datta.
Third one.
But that application
First and
can be
second.
on record.
তাই তো? আচ্ছা, items 2 and 3 দিয়ে। আচ্ছা, item 3 আর supplementary affidavits filed in connection with IA number GA 1 of 2023 within bracket in AP 155 of 2023 and IA number GA 1 of 2023 within bracket in AP 156 of 2023 bracket closed, comma filed today be kept on record. Full stop. On the prayer of learned counsel, the matter is adjourned and shall next be listed in the monthly list of June 2023.
Grateful.
আচ্ছা, কালকে শুধু মোশন গুলো আর যেগুলো কালকে বিচার
Item number 5, Mrs. US Infra Developers Private Limited versus
Learned Counsel Mr. Jishnu Chaudhary is leading me in the matter. My lord, may I come back after the vacation, my lord?
Why not? You are for the petitioner.
I am for
You
the
have no
petition.
difficulty.
No.
Good. On the prayer of the petitioner, the matter is adjourned and shall next be listed in the monthly list of June.
I'm deeply
Item number 6, Shrey Equipment
I'm
Finance.
for
6
the
to 9
applicant.
similar matters?
Similar matter.
6 to 9 board দেখাতো। Yes.
For the respondent, my lord.
My lord, this is my application, my lord. It's a hire purchase agreement, my lord. Master lease agreement, my lord. They were to pay, my lord, installments as lease installments, my lord. They have not paid. They had defaulted. We had made a demand notice. Thereafter, Section 21 notice, my lord. After that, we have filed this application, my lord.
Session, any objection?
Yes, your lordship. The only point of objection is that firstly, I would pray for an
First, let me see
opposition.
the arbitration
Your
clause once.
Yes, yes,
Yes,
sure.
the arbitration clause, my
Just
lord.
that. Yes. The
Please,
clause and
page 23, my lord. At the top, my lord, N.
the agreement is one for
Yes, ma'am.
It's a
Master lease
leasing
agreement, my lord.
bus. Very. And where is the invocation? Which page?
Invocation. My lord, page 21. No, no, no,
No,
my lord.
21 cannot.
No, no, no.
No, no.
21 is the agreement.
Yes, yes, my lord.
The invocation is at page
53, my lord.
53.
Thank
It kindly takes that invocation notice, my lord.
All right, start from there.
My client,
Hmm.
Punjab National Bank, through agent constituted attorney or constituted attorney Shrey, who files Shrey. The loan agreements have all been assigned to Punjab National Bank. Shrey is acting as their agent. Shrey cannot maintain this application in its own name.
My lord,
Well, these applications are all suffers from incurable defects, my lord. Shrey cannot maintain this application in its own name.
my lord,
Item numbers 300, AP 317, 18, 19, same.
my lord, with the deed of assignment, my lord, it was assigned. Thereafter, we have made an agreement of service agreement where the Punjab National Bank has given us the authority to file against, to recover the dues against those agreements. And in the agreement, my lord, in page number 21, there is a assignment and agency, clause 16, my lord, if you check, my lord. Kindly comes to page 21, my lord, clause 16.
16 or 15?
Clause 16, my lord, assignment and agency, my lord.
Oh, acha, yes.
Yes, the lessor may sell or assign the transfer, assign or transfer all the lessor's right and obligations under this agreement, my lord. So the lessor by deed of agreement, assignment, my lord, it was
Yes.
transferred. Thereafter, the under services agreement that is annexed to it, my lord. All the Punjab National Bank has given us the authority to file any proceeding against the borrowers to
On
recover
their
the
behalf.
dues.
On their behalf. On their behalf.
No, that
Even
is a
the
tribal
master-
issue before the arbitrator.
No,
my
no,
lord.
no, not at all.
Yes,
My
ma'am.
lord, who
No,
files the
Whether
petition?
you can
is
maintain
not
the
at
section
all.
11 application or
No,
the
no,
invocation.
absolutely not. Yes,
That
my
is
lord.
what
They
there.
cannot maintain. My lord, the petitioner ought to have been Punjab National Bank. Their person could have signed in view of the assignment and in view of the service agreement that they have entered upon. Everywhere it says
But
that
Mr. Sen,
Shrey,
in the master lease agreement,
yes, your lord.
regard in which the arbitration clause is found, page 11, it's Shrey equipment, that is the lessor,
Yes, my
labeled
lord.
as a lessor.
But my lord, the loan agreement, including the master service agreement, stands assigned in favor of PNB. That is their contention. And that assignment agreement is also annexed.
The
to this
dispute is
application.
regarding that also.
No, my lord,
Also,
dispute is regard to
dispute
the
is
agreement, my
regarding
lord.
the master service
Mas-
agreement, the original one.
If there is no dispute regarding that, then if you have admitted that it has been assigned
It has
to
been
PNB,
assigned.
My lord, it has been assigned, but they have given the authority under this agreement that I can proceed
To
against it.
file on their behalf,
Let
not
us
to act in their own capacity. They are the agents of PNB.
My lord, kindly comes to page 111, my lord.
My lord, kindly takes page 108, 109.
111, my
application.
lord. Appointment of the
Yes.
appointment of servicer, my lord.
Hmm.
In pursuance to deed of assignment, the assignment here assignee hereby appoints Shrey Equipment Finance Limited inter alia for the purpose of managing, collecting, processing, servicing, and receiving payments of receivables, and to deposit the same in collection of the in collection and payout accounts to enable distribution of the assignment payout therefrom. Provided to provide certain other services and appoints Shrey Equipment Private Limited as agreed to be appointed as the servicer on terms and conditions hereinafter agreed. The servicer shall we pay the fee, services fees in accordance with the waterfall mechanism.
This is
Kindly
not for representing them in
Yes, kindly see page
litigation.
113.
I'm coming from that.
Page 113, my lord. Collection and receivables. Everything is for and on behalf of the assignee. 113, my lord. Clause 4.1a. The servicer shall do all such acts, deeds, and things as may be necessary, including by way of obtaining and depositing post-dated checks received from the obligers for and on behalf of the assignee. And which checks may, if the
No, you have not
servicer.
been empowered to litigate in court.
Yes.
Just
Doesn't
give me a moment.
appear.
Even if they're
Litigate in
empowered
court
to
or elsewhere.
litigate, even if they're empowered to litigate, they are empowered to litigate on behalf of PNB. They cannot file in their
SCM
individual
was
capacity.
that also.
Yes, your lordship. They cannot file in their
So in the
individual
cost title,
capacity.
there's nothing of that
Kindly
sort.
seize the cost title as well as the affidavit. Who has affirmed? There is a doubt in respect of the affirmation also, because Shrey is under CIRP. I don't know whether this person is effectively authorized to file this application.
Take instructions, come back before a
sir.
different bench. If changed,
Okay, my lord, I'll
take
take instruction.
take the risk. Here it will be rejected definitely.
No, my lord, I'll take instruction.
I'll record his points, but
Yes, ma'am.
Well, this is for item numbers 6, 7, and 8.
6, 7, 8 একসঙ্গে একটু বোর্ডে দেখিয়ে দিতে।
Well, kindly allows me to file an opposition to this. 1 week after the vacation,
Very
we
well,
file.
I'll do.
That will be convenient. The
Very well,
point
I'll
will
do.
be on record.
I'll direct opposition. So in the meantime, no opposition, or if you want to rectify and take back and file afresh, I mean,
My lord, let them file our opposition. my lord.
1 or 2 weeks after the vacations, if it is convenient.
at the outset, learned counsel for the respondent opposes the application under section 11 of the Arbitration and Conciliation Act 1996, primarily on the ground of maintainability. It is pointed out that although the PNB within bracket Punjab National Bank is the assignee with regard to the loan agreement, comma, the present application has been filed by the Shrey Equipment Finance Limited. Full stop. Next para. It is further submitted that Shrey is, comma, in all probability, comma, under CIRP within bracket corporate insolvency resolution process, bracket close, and, comma, as such, comma, it is also doubtful whether the manager, legal, and authorized signatory of the said company can maintain the present application. Full stop. Next para. Learned counsel for the respondent seeks to file affidavit in opposition. Full stop. Accordingly, the respondents are directed to file their affidavit within bracket S within June 9, 2023. Full stop. Reply, if any, shall be filed by June 16, 2023. The matter shall be listed for hearing on June 19, 2023.
No, then item number 9. That is
As the
three
same order will be passed in all the three.
No.
All the
No, 3
questions. Yes, yes, ma'am.
6 to
Yes, 6, 7, 8, my lord.
6,
Same
7,
order.
8. Yes.
Let 6, 7, 8 can be same, my lord. Even for item number 9, my lord, I have a doubt expressed in respect of the affirmation, and also the point of limitation is also involved, my lord. My lord, in that regard, I want to file an affidavit in opposition in item number 9.
Let 9 be called on. I'll pass a separate order.
Yes.
Item number 9.
9 filed.
Filed.
Limitation and
Limitation and legal
CIF.
affirmation.
affirmation objection on same ground.
Yes.
Learned counsel for the respondent takes an objection with regard to the maintainability of the present application, comma, on the ground of limitation, as well as whether the manager, legal, and authorized signatory of the petitioner company has the locus standi to file the present application on its behalf, comma, in view of the company being in a CIRP within bracket corporate insolvency resolution process, bracket close, full stop. On the prayer of learned counsel for the respondent, comma, the respondent is directed to file affidavit in opposition to the application by June 9, 2023. Full stop. Reply, if any, by June 16. the matter shall be listed on June 19th.
Much obliged, my lord. My lord, the survey, affidavit of serviceman.
In all the matters, you have checked up all the matters.
Yes, my lord.
Affidavit of service be kept on record. প্রত্যেকটাতেই আলাদা করে।
Obliged.
Much obliged.
Finally, appearance to the appearance. Item number 10, Shankar Ghosh.
My lord, I appear for the petitioner, my lord.
Yes.
My lord, it has been served, my lord, but the affidavit of service could not be affirmed, my lord. No, there was nobody in the department. My lord,
Good service has been effected.
yes.
You are appearing for the respondent. It has not been affirmed.
Not
Can you get it affirmed during the course of the day?
yes.
I'll give you leave and hear the matter. Yes.
My lord, this is an application under section 11, my lord. The dispute has arisen. There was a partnership agreement between the parties, between the petitioner and the respondent number 1 and the husband of the respondent number 2, who was the partner. My lord, after the death of the Ganesh Dubey, the husband of the respondent number 2, she stepped into the shoes of the partnership agreement. My lord, the partnership,
Give the microphone.
the partnership agreement is annexed, Annexure B. My lord, start
Yes.
from page 22.
Yes.
Well, let kindly come to
No, 21, I'm sorry.
21 itself. My lord, kindly come to clause 21, page 39. My lord, this is the arbitration clause.
Page 39.
Yes, my lord.
In my copy, page 37. Anyway,
37, my lord. Yes.
got it? Yes.
That is the arbitration clause. And my lord, there is a clause in case of death. My lord, the legal heir will step into the shoes of the legal heirs will step into the shoes of the deceased. My lord, the respondent number 2 stepped into the shoes of Ganesh Dubey. My lord, there is a dispute arisen. My lord, notice has been issued. They did not respond. My lord, thereafter section 21 has been invoked.
Are you opposing this prayer? On what ground?
My learned friend referred clause 21 of the arbitration agreement. Sixth line from the top of that particular clause. The same shall be referred for adjudication to the arbitrator appointed individually by both the parties. But here they have implemented 2 of us as respondent, and he himself is one of the party. Then, my lord, in case of difference of opinion of the 2 arbitrators, the same shall be referred to a 3rd arbitrator. If the 3 parties are there, but according to the agreement, there cannot be, my lord, the 3 arbitrator. It only refers to 2 arbitrators. And here, my lord, he implemented 2 of us as respondents. And so far as, my lord, the death stepping into the shoes, my lord, that is also, my lord, is not the intention of their agreement.
There is no such clause.
Yes, death clause is there. But death clause is for.
Can I decide this in section 11?
No. But he has said that one of the respondent has been implemented.
Yes.
But so far as this agreement is concerned, she is neither here nor there. And by virtue of this death clause, according to him, he has been implemented as one of the party respondent.
Suppose she is not. It's a misjoinder of party, not a non-joinder. So it's better to have a misjoinder than a non-joinder. Misjoinder is not fatal for a proceeding. Non-joinder is fatal. Non-joinder of necessary party entails that the matter can be dismissed. But misjoinder is superfluous.
So far as the arbitration clause is concerned,
yes,
when the clause refers to the 2 arbitrators.
So what? I mean, it's a bad clause, do you say?
It cannot fit in the present circumstances of this case, for which he is seeking arbitrator. But your lordship kindly see.
I don't understand your point. Yes.
Subject to lordship's sanction, I think it is a copy paste because there was initially 2 partners. Then it has been dissolved. But though the accounts has not been dissolved, the partner's contribution has not been spelled out in the agreement, whatever may be.
Oh, there were 3 partners in this.
Yes.
That's why you're saying.
My lord. He is now saying 3 partners. Therefore, non-issuance of notice and all these things, everyone will hit this. He is referring arbitration clause,
But you are a signatory to it also. You are a party
Exactly.
to it.
but I may be a party.
Can you not resign?
But I may be a party, but so far as the invocation of arbitration clause but cannot fit in the agreement.
My lord, in reply, my lord, I will say only one thing. My lord, I have referred.
This is your main ground.
This is one prima facie ground, my lord, because of the fact, my lord, just in the morning I received this, and my lord, I have come because I know your lordships, my lord, your lordship is not making any adjournment, and that's why I'm making this
No,
submission.
not that. If you want to prepare yourself better, you can come back tomorrow.
My
If
lord,
you have something else. Is there something else here?
my lord, I think,
My
my
lord,
lord,
my lord, in
it is
reply
going,
only.
my lord, at the root of this, because the reference is one of the main, one of the.
So this ground is one of the valid grounds. I mean, you could arguable grounds. But any other ground, I mean,
My lord,
you can come back tomorrow. Then come back
My
tomorrow.
lord, instead of, my lord, if your lordship allow me to file affidavit, my lord, I will come up with an affidavit. My lord, and then my lord, apprise your lordship. So far as this part is concerned, and my lord, so far as the deed of agreement, my lord, the stepping into the shoes, but very, my lord, very
That is disputed.
very common thing in one of all these partnership agreement.
Yes.
But my lord, if the agreement doesn't, my lord, permit for stepping into the my lord, shoes,
Suppose she does not step into the shoes. It's a superfluous joinder of that person.
my lord, there is in this my lord, the petition itself, there are specific my lord, the aspersion or my lord, the allegation against so far as the misappropriation of fund and all these things has been spelled
I'll
out.
record that is dispute. This is not a pleading. Section 11, whatever has been said by them, that is not pleading and that will be deemed to be denied by you. Definitely.
My lord,
That does not require an
this is one part. One, so far as my lord, the execution, my lord, the approach under
Yes.
section 21, and also my lord, so far as the my lord, this interpretation of the arbitration clause, but my expectation is very much hit. And so far as my lord, the notice that has been sent, that is in the month of
June.
June.
Hmm.
And then my lord, this application has come now. My lord, I think so far as the clause 4 of that section 11, my lord,
after 30 days.
after 30 days, not any time, my lord.
After 30 days, this is after
No, that is it. But
not
so far-
unreasonably long.
but unreasonably long.
Not un-
My lord, your lordship kindly, my lord, if your lordship,
No, this is a good point. Let me hear him rebut it. Section clause 21.
my lord.
My lord,
Yes.
the clause 21 says that each
Why
party-
shouldn't the arbitration clause
each-
itself
each-
go?
Each party should appoint their own arbitrator. My lord, I have named by arbitrator. I have sent.
No, not that. Arbitrator appointed individually by both the parties. So that is where the shoe is
My
pinching.
lord, this I have sent letters under section 21. They have received it. They didn't reply. Even the demand notice was not replied. My lord, if they should have taken that point earlier, that could have been a point. My lord, they have not replied any of the letters sent. Neither this letter, neither the demand notice, neither the section 21. My lord,
My lord,
They-
so far
they
as the
have- they-
notice is concerned,
they-
Get your point.
but,
Yes.
they
but
have
so far as notice is concerned, according to them, that it has returned unserved. Therefore, knowledge of notice and the text of the notice was unknown to me, but it was a valid service.
No, I'm inclined to refer it to arbitration.
My lord,
I'll deal with your points definitely.
my lord, subject to lordship
This
sanction.
is a very arguable question. I mean discuss it.
My lord, both, my lord, once it has been both, and then my lord, it is specifically stated two arbitrators.
Hmm.
my lord,
Not that both means all, three, but
my lord,
it refers
there-
to
there-
two.
There were
But the intention to refer to arbitration is very clear.
yes.
My lord, that is
My lord,
true.
there is a dispute.
Because if there is a dispute regarding the procedure of appointment, that can be taken care of in 11, 4 and 6. 6 rather.
My lord,
That is the difficulty on your part. I mean. So even if there is a dispute regarding the procedure, that can be absolved by under section 11, it can be. But the intention to arbitration, refer it to arbitration is very clear. From it.
my lord,
That is the difficulty.
my lord, that part, my lord, only can be, my lord, clean if it was, my lord, properly spelled. There, my lord, your lordship will find the question of three partners is totally, my lord, not considered. But my lord, in all other part, they have referred it three partners. Not that both
No,
partners.
no, partners' names are also given. It's clear that there are 3 partners.
Yes.
But when this clause comes, he's, my lord, converted into two. Who are those two? Why should I reply? Two means he himself and one another. Who is that another?
My lord, the
He
fact,
loaded it at 2%.
my lord, the fact remains that the partnership is still continuing, my lord. I am in dark.
No, no, not about the partnership. The arbitration, I have
Arbitration
you
clause.
have to satisfy me on this because your learned friend is right in saying not only touching the business of the firm shall be referred for adjudication to arbitrator appointed individually by both parties. After that, it is followed by in case of difference of, he is right. In case of difference of opinion, the two arbitrators shall be referred to a third arbitrator. So how can this, I mean, this is not even feasible.
My lord, what has happened, my lord?
There cannot be any
there-
interpretation to it
there-
which would turn it valid.
There are three partners. There are three partners. So one
Two on one side and the other.
yes. So there is two. Actually, if there is a dispute between three, then my learned friend could have argued on this point. There is a dispute between the two. The first part and the second part means the two.
My lord, there
That's
is,
a possible interpretation.
my lord, but the pleading doesn't say
But
so.
there-
But
my lord,
Difficulty is here at this stage, section 11, if there is a possible interpretation, then the intention of arbitration, referring to arbitration has to be taken note. My charter is very limited in section 11.
my lord,
I'm not section 9 court or the arbitrator.
my lord, one indulgence I am praying, my lord. Certain my lord, instructions are coming. My lord, your lordship keep it tomorrow. I will, my lord, coupled with this argument, I will make one more argument. So far as my instruction, it is not properly, my lord, received. That's why I cannot say. But
Learned counsel for the respondent seeks an adjournment to take further instructions. Accordingly, let the matter stand adjourned for the day. Please come back to us.
my lord, I'm sorry, my lord. wasting
No
valuable
question of
time.
that. No question. I'm here for these things only. Please come back to us. Next.
Adjourn motion, item number 11.
My lord, I'm
The
appearing for the
industrials.
petition. I'm opposing, my lord. Your lordship had granted me time. But I have used an affidavit. I found that there are possible objections to the. My lord, we have received the opposition, my lord. My lord, I was craving for some time to file the affidavit and reply because I'm awaiting some instructions from the client.
How long? Tell me.
My lord, some instructions are required from the client which I have not yet
Don't
received.
hesitate. How long? How long
My
do you
lord,
require?
1
month,
week
2
after the
months?
vacation.
Pardon?
1 week after the
Only
vacation.
1 week after. Don't hesitate. Affidavit in opposition filed today be kept on record. Full stop. The time for filing reply is extended till June 9, 2023. Full stop. The matter shall next be listed on June 12, 2023.
Deeply pledged, my lord.
Appearance.
Yes. Call on next.
Court applications, item number 12.
My lord, my
Careless
petition, my
feelings.
lord. That matter, my lord, where, my lord, the respondent bank, my lord, which is the admitted position, my lord, that entire loan, everything was repaid. Now it was their time, my lord, to give me back my title deed. Yes, my lord. That 1400 acres of land as a tea garden. Now, my lord wanted me to file a supplementary affidavit in order to ascertain what more documents towards
Yes,
my.
there has to be a solution to
Yes, my lord, there has to be a solution, my lord. My lord, 3 avenues, my lord, as it was discussed, my lord, amongst us, my lord, that one is, my lord, that we have prayed for is the compensation because this is a huge amount of land, is a tea estate, entire tea estate, the original title deed, my lord, they have misplaced. And that is glaring.
That has to be a suit then, not in this petition.
My lord, that I will
I'll
satisfy.
give you liberty to.
No, my lord. My lord, may I?
How can I calculate? What is
Yes,
the
my
basis?
lord, that I will, my lord, that I will ascertain. There are judgment because this is the
No,
compensation.
there are several judgments which can also pass compensation.
Yes, my lord, that I will.
In this case, there
But
calculation.
there are other, my lord, there are other avenues. That's why my lord wanted me to come back with a supplementary affidavit showing my ownership. My lord, that one is, my lord, who is the, but one is that, my lord, the registrar of Tripura, my lord, the registrar of the Tripura High Court, because the Honorable Tripura High Court, when the matter was filed before the Honorable Tripura High Court, Honorable Court found that since the company had entire cause of action that belongs to that is the cause of action lies for the purpose of adjudication before this honorable court. So this honorable court have whatever right is there, it is with this honorable court. That was the categoric finding of Tripura High Court, my lord. So my lord, the registrar of the Tripura can be directed, my lord, to execute a conveyance at the expense, entire cost and expense of the Allahabad Bank. That is one avenue. But the
How
second
can
is,
the registered Tripura High Court do that?
my lord, because my lord, My lord, because if my lord, even the certified copies are also not found, my lord.
Registrar of Tripura High Court, how can he or she?
My lord, my lord, here, my lord, also.
What was pending there? What proceeding? Section 11? I'm sorry. A writ petition was pending
Yes,
there.
yes, the Honorable Tripura High Court, my lord, found, my lord, that this Honorable Court has the jurisdiction on that point. We were.
Just because of that, how come?
Not only that, but not only that, my lord, and I have also come, my lord, I have gone to the official website of the Revenue Department of Tripura. But I have found, my lord, the concerned person, my lord, because if we can trace out if that can be traced out from the land revenue records, land records, my lord, that is another.
In this case, you are not getting certified copies also.
No, they are not. Well, the Honorable Justice Banerjee, Honorable Justice.
I'll give you leave to apply for certified
But
copies.
no, those are all done, my lord. Kindly see the earlier.
Taken certified copies.
No, my lord, that is not possible, my lord. Kindly see 29th April 2015 order.
Why is it not possible? Just tell me, indicate.
My lord, the respondent bank was directed to make all the arrangement to obtain the certified copy. They also.
You apply, they'll bear the costs. Can it be done? Why can't it be done?
My lord, we had, my lord, that is not traceable. No record is traceable.
The registry office also.
Yes, my lord. And my lord, now, my lord, this authority, this person, I had gone to the official website. Official website of the Tripura land authority.
Records and settlement.
Yes, my lord, this is the person concerned who keeps the record, my lord. If your lordship kindly direct him
You can
to, my
apply
lord,
for register certified copies of these documents from this authority.
certificate copy, those are all done, my lord. That
Where
could not.
show me that. That is all done. Who did it? You did it.
No, certified copy.
Apply for certified copies. Get the certified copies. If you don't get the
This
certified,
is not traceable, my lord. This is, my lord, kindly.
where do I find it? Show me.
My lord, kindly come to the order, my lord, passed, my lord, by Honorable Justice Banerjee, my lord.
That was in terms of the direction for them to file certified copies. Find out certified copies. You do that, they'll pay you damages or whatever.
But we
The
had-
costs of
but
registration definitely they'll bear.
Document is traceable. Kindly, my lord, if your lordship.
How can you say that no document is traceable?
But because our.
Show me that order.
persons-
Which order? Dated?
But we had made searches, my lord, as an instructor, we had made searches, but no document was traceable.
Where is it disclosed?
Not disclosed. Not disclosed. If your lordship kindly direct this person, my lord, to find out, my
Why
lord.
should I direct? He's not a party. He's no.
But he is the person, he's the record keeper, my lord. Entire
No.
land record, my lord. Kindly see, my lord. He is the highest
You have to
authority there.
apply for certified copy first before the appropriate order. Let us see what the bank says. Yes.
Lord, the first thing, my lord, your lordship will kindly see whether he has the locus. My lord, he seeks the title deeds. Lord, your lordship will kindly take, my lord, my affidavit in opposition once. My lord, initially, my lord, when this writ petition was moved, my lord, I thought he has a cause, he has a case. My lord, I seriously doubt whether he has a cause. And my lord, I'm certain that he has no case. Your lordship will kindly take, my lord, page 53 of my affidavit in opposition.
Yes.
53, my lord, is a written objection, my lord, filed by, my lord, the writ petitioner before the DRT in the original application, which was instituted by the bank, my lord, for recovery of loan. Now, my lord, kindly turn to page 55. My lord, last paragraph, subpara H. The applicant bank has also with malafide intention suppressed the fact that the defendant number 1, that is the writ petitioner, is not the owner of any tea estate. The applicant bank has been fully aware of the fact that both Selim Hill Tea Estate and Phatickchera Tea Estate, not Phatickchera is the subject matter of this writ petition, were already transferred, and the same is no longer in the control, management and administration of the defendant number 1. Lord, this is 1. Your lordship will kindly take, Lord, page 57. Lord, paragraph 7.
Yes.
Lord, about 10 lines from the bottom of the paragraph. Lord, the line begins from defendant number 1.
Yes.
Lord, about the end of the sentence, the defendant number 1 states that since the defendant number 1 is no longer in control, management and admission of business of tea estate, the question of payment of proceeds of tea to the bank and or there being any hypothecation of teas in favor of the bank does not arise. It is denied that the defendants are under obligation to deposit the sale proceeds as alleged or otherwise. Now, my lord, he says that he is not the owner of the tea estate at all, not even Phatickchera Tea Estate. Now, my lord, there is something more. Your Lordship will kindly take, my lord, page 43. My lord, page 43 is a part of an application, not a written objection. An application filed, my lord, by the defendant number 1 before the Debts Recovery Tribunal at Calcutta, my lord, praying for certain reliefs. My lord, your Lordship will find the application. My lord, it begins at page 35. Your Lordship will kindly take page 43. Page 43, my lord.
Kamala T.
Yes.
My sister.
My lord, very well, whoever it is. The defendant number 1 petitioner states that on and about 1/1/1995, Fattichera Tea Estate was transferred by the defendant number 1 petitioner to Komala Tea Company Limited. Transfer of the said Fattichera Tea Estate by the defendant number 1 petitioner to Komala Tea Limited will inter alia appear from such and such, such and such, such and such. Now, my lord, today he comes up. My lord, the title deeds are mysteriously missing, not from my custody. My lord, your Lordship will kindly have a background of this case. My lord, the loan was initially taken, my lord, from United Industrial Bank of India Limited. My lord, an entity which merged into Allahabad Bank, my lord, sometime in 1987. The loan precedes the date of merger. My lord, before the merger, United Industrial Bank of India Limited, my lord, had instituted a suit for recovery of, my lord, its dues and, my lord, for enforcement of the mortgage. My lord, in that suit, the title deeds, my lord, were supposedly deposited. My lord, the bank came to the conclusion from a noting on a file. My lord, no document to that effect. From a noting on a file, my lord, we came to this conclusion. Now, my lord, upon the suit being, my lord, upon, my lord, the 1993 Act coming into force, the DRT Act, my lord, Recovery of Debts Due to Banks and Recovery and, my lord, Financial Institutions Act, my lord, the suit was transferred to DRT. My lord, there was another suit in one proceeding in Guwahati DRT, one proceeding in Calcutta DRT. My lord, we did not have knowledge, my lord, where the title deeds went, my lord, because of the transfer. My lord, it was administrative transfer, my lord, all across, my lord, the country. This happened upon, my lord, the 1993 Act coming into force. We did not have any hand in that. My lord, upon the loan being, my lord, set off, my lord, by paying, my lord, the compromised amount, my lord, we, my lord, returned the Selim title deeds, my lord, pertaining to Selim Tea Estate, my lord, which were also deposited with the bank since we obtained it from the court. My lord, this we could not obtain from the court. There is a categoric averment also to that effect. My lord, subsequently, my lord, even subsequent to institution of the writ petition, my lord, bank, my lord, inspected the records, my lord, came to searches, my lord, and we could find, my lord, one title deed, which, my lord, we had supplied, my lord, a copy whereof, my lord, to, my lord, the advocate, my lord, was appearing in on behalf of the writ petitioner prior to my learned friend entering. My lord, to that I do not know what their stand is. And, my lord, so far as this is concerned, your lordship will kindly see the supplementary affidavit, my lord, which my learned friend, my lord, has affirmed, which my lord, runs into 3 volumes, my lord, showing, my lord, his ownership. My lord, these are not the properties, my lord, which appear to be, my lord, appear to have been mortgaged, my lord, by the writ petitioner to the bank. My lord, if your lordship sees, the mortgage was in respect of a leased property. We do not even know, my lord, whether the lease has been extended. My lord, the properties do not match. Lord, how will your lordship, my lord, in my very respectful submission, decide these disputed questions of fact? And my lord, this fact that he has transferred was not even, my lord, whispered in the writ petition. My lord, the writ petition should go on that ground alone. My lord, I need not, my lord, travel further, my lord, and trouble your lordship with any other pleading. My lord, if I can show, my lord, from the writ petition itself, nothing has been averred. And when, my lord, we make out this case in the affidavit in opposition, they become smarter in reply and they say, no, conveyance has not been completed, because the title deeds were not available. Now, this ought to have been written in the writ petition then. Today, he says sister concern, brother concern. Lord, all these sisters and brothers had vanished in the writ petition. If Bank, my lord, had failed to lay, my lord, hands upon this, my lord, he would have walked out. My lord, there is something very sinister, very mysterious, my lord, happening behind this. My lord, 25 crore in respect of a property of which he does not claim ownership, which, my lord, he admittedly claims to have transferred. My lord, he says today, he says it's my brother concern, sister concern. Where is there, my lord, in my very respectful submission that, my lord,
have you used the reply to this?
Yes, but
What is your stand on this?
But may I each and every, because I was making my submission, each and everything I have to make clear, because in the mid of my submission, my friend was called upon to give my lord. May I, my lord, to start with, my lord, they had taken my lord first to the page 43 of their opposition, my lord. Yes, my lord, is the defendant number 1 petitioner states that the applicant bank was fully aware of the fact that both the said two tea estates have been transferred and or are no longer in the control, management, administration of the defendant number 1 company or the petitioner company, suppressing the fact and by misrepresenting the material facts of this learned to this learned tribunal, the applicant bank has persuaded this learned tribunal to pass an order so and so. My lord, what is the bank, my lord? What is the case simplicity? We had taken loan, we had mortgaged the property by depositing original title deed. Bank now, when the loan has been entirely repaid, it is now duty or the obligation of the bank to give me back the title deed. Not to, my lord, the bank is trying, my lord, to escape his own responsibility by saying, but even if I come to this transfer, how can this transfer be effected without the original title deed? Who is the person is going to take without seeing the original title deed? It is, my lord, from...
That was your defense.
No, not only my defense, my lord.
That was your defense, your application and your defense in that proceeding.
My
On
lord,
oath, you have stated that
yes,
has been transferred to Kamala. You have given the name of the bank.
not be transferred, but it was, my lord.
That's your assumption. You have stated it has been transferred. Could
But
have been with
Lordship,
certified copies.
My lord, we should also...
Why not with
Bank,
certified
my lord.
copies? Where is the bar?
But certified copy is not available, my lord.
At that point of time, could have been transferred.
And my lord, what...
If you handed over certified copies of the transferred, why not? And you lied then or now? Why not now?
My lord, there is no question of lying, my lord, but have been transferred by my...
You have stated was transferred
Yes, my lord, but the transfer...
on a prior date, not even on that date, on a prior date, could have been before the loan also. How do we know? You have not specified that here. You said it had been transferred.
It is written, my lord, but we should, we should dug out the fact whether it is at all transferred.
What is written is not the fact. What you are telling now from the bar is the fact.
That, my lord, it could be, my lord, that HON'BLE tea was my sister concern, but this transfer, my lord...
Where is your sister now?
HON'BLE
She has
tea
been married out to some other company.
not be, my lord, it could not be finally transferred, my lord. But there are, my lord, the main points, my lord, kindly see, my lord. These all points, my lord, have...
Your prayer is malafide then. How can you claim this title deeds after you say at that point of time, you said that you had already transferred.
But,
and in several places you have stated.
no,
Where is your locus standi? He's right on that. I mean, you're claiming compensation also in lieu of this.
No, my lord, not on this, my lord.
You're trying to get
And the
not only unjustly but illegally rich.
perhaps
Your
not,
client, I mean, obviously.
perhaps not, my lord. Perhaps not, my lord. But it's written, my lord, has transferred. I'll definitely, I have to take instruction, my lord, on this, my lord. Why?
What instruction will you take? This is your objection. You have used a reply against this. Whatever instructions you had to take, you already have taken. You have used your reply against this. At the hearing stage, you cannot get further time for getting instructions. No.
Not on this, my lord. There are other points. But kindly see.
No. How do you deal with this point? What is your locus standi? You have to get over this first. You have got no locus standi.
Transfer has been effected, my could not be without the original.
Dismiss. It should be dismissed with costs actually. For this, not only for suppression of this, but for this itself, you don't have any locus standi. You knowing fully well, as you said against the bank. And at that point of time, they might have known fully well whatever case you had. But now, as on today, this remains. No.
But it is not transferred. But kindly allow me to
unnecessary and futile exercise.
One document, Lord, so that he can answer, Lord. One more document, Lord, page 65.
And my lord,
Page 65, Lord, this is from the revenue records. Lord, this I missed.
My lord, the supplementary affidavit, my lord.
Supplementary affidavit, Lord, will be supplemented, Lord.
My title, my lord, my
Page 65 also is added to your agonies.
Page 65, my lord. Page 65, the Lordship will see the, my lord, entry 5. Phattacharya Tea Estate. My lord, right hand side, your lordship will see at the top name of owner and address. Your lordship will find Kamala Tea Company. This is mutated in the revenue records. My lord, this was annexed to the affidavit in opposition. My lord, I am not, my lord, bringing out papers, my lord, from pocket and handing up to court. My lord, these are revenue records.
You obtained this?
Yes, my lord. My lord, this was available on website.
Yes, obviously.
I stated that, my lord.
My lord, Kamala Tea Estate, my lord, is my sister concern. My lord, it is. But is the case, what is the subject matter of this? But the bank has taken, my lord, the original title deed. He has failed to return it. He has to give me back the same. But my right to get the original title deed does not go. Who has repaid the loan? Is it Kamala Tea? But I have repaid the loan. It is my right to get back the title deed, my lord. Does it go, my lord? But allow me to come back with instruction.
no,
Tomorrow,
no,
my lord.
objected
Tomorrow
on the
itself,
last
my lord.
occasion.
Tomorrow itself, my lord.
Don't come back, go back with an appeal against my order.
My lord, my lord. May I, my lord?
Definitely not. Not a single modi.
My lord, my right, but then, my lord, may I show certain documents, my lord?
Learned counts. Any subsequent document after this
Yes, my lord.
averment?
Yes, my lord.
After this averment?
But the supplementary affidavits wherein, my lord, I have given all the tax receipts, khajna, everything. But everywhere,
which
my lord,
date?
my
Which date, which year? Which year?
But these are, my lord, all updated, my lord.
After 1995? Updated till when? It's like somebody referring to a 68 judgment and saying that this is the latest judgment on the field.
No,
Might be the latest judgment. There may not be subsequent something. But after 95, you are saying it's updated. What do you mean by update exactly? একটা নেই কিন্তু তো চান্স দিও না না বস
The documents of 2011, my lord, wherein I have been
what does
declared
it say?
রায়ত এবং হোল্ডিং এর বিবরণ এখানে here, my lord, I have been shown, my lord, the fearless team have been shown as, my lord, the riot. My status has been shown, my lord. রায়তের নাম in Bengal, the fearless tea company limited, that is mentioned, my lord. There are 3 documents and all these khajna receipts and everywhere, my lord, my name is appearing, my
The
lord.
properties are where? Tripura.
Tripura is a tea estate, my lord.
Yes, but
Total land, my lord, measuring about 30.
but this page 65 document, if you come to that, that is the land records of revenue department, as you were saying. You are relying on that they must have the records. So this is their records.
Paying khajna will not endow them with.
Yes,
ownership.
exactly.
My name is appearing as riot, my lord. The documents that, my lord, I am trying to refer to, my lord.
Earlier document prevails unless you show how you became the riot after this.
My lord,
And Lord, he has to show the mark, my lord, the lands, my lord.
nowhere it
There
is
cannot be
stated-
backward presumption.
No, my lord, nowhere it is stated that in respect of the entire tea estate or the entire tea land, my lord, this particular, my lord, entry, my lord, I have to, my lord,
Where will, Lord, I rely on his submission only.
No,
Lord,
the
not-
Photichera tea estate, the
Yes,
name of
sir.
the owner, the entire estate, the name of the owner has been shown as Kamala tea. And that was as per in accordance with your averment only.
my lord, the area
No, no.
under tea during so, my lord, production of own tea leaf, my lord, this is a record, my lord, I think. This is not a record of the, my lord, the holding of the land, my lord, right? It is relating to the tea production of the tea.
Have you dealt with these documents in your reply?
Yes, yes. Not denied. Lord, paragraph 4 of the reply, my lord, is the sole answer, my lord, to several paragraphs of paragraph 5, sub-paragraphs of paragraph 5. Paragraph 4, my lord, runs into 1.5 pages. Lord, for the first time, this case was introduced that it was sold, a deed of conveyance could not be executed. Lord, writ petition, Lord, conspicuously silent on this.
Malad, kindly see, Malad. Under paragraph 5, Malad, kindly read, Malad. And at page 10, Malad, 4 lines from top, Malad. The respondent bank has prevented the petitioner from transferring Fattichary estate and has affected the marketable title of the safety garden by reason of non-return of the original title deed.
But this is not the writ petition.
And they say, Malad, that I have already transferred. So it is.
I don't say, they
But
say.
kindly see, Malad, it is a subsequent reply, Malad. And it is my stand, Malad.
This is contrary to your stand in the written notice, which was prior to this.
Yes, Malad.
Did you ever take out the take this point of they're losing the title deeds before this writ petition? If you did not, then the prior stand prevails. You took a stand specifically to have transferred it. Subsequently, you filed this writ petition. In a reply in that writ petition, you state something which is contrary to your earlier averments before a court of law or some forum.
Letters and correspondence were given to them to.
All are subsequent to that averment of yours.
But kindly see the interdepartmental letter of this bank, Malad. Kindly come to page 25
Of
of the writ petition. The Lordship will find, Malad, if I am permitted, sir,
Yes, that is the precursor of the writ petition. I understand, Lord. No, this, my lord, is the whole source, my lord. We go against this person also.
yes.
Is the interdepartmental correspondence of the bank officials, Malad. Kindly refer to page.
They can in fact claim a compensation suit against you for harassment.
Malad.
They can claim a suit for compensation against you for harassment, your client.
After losing the,
Yes, they did interdepartmental so many things and all for nothing.
Lord, interestingly, my lord, no copies.
Please,
marked
sir,
to him.
please take a seat. Yes.
Kindly, Malad. Kindly refer to our correspondence as mentioned below, and the last being so and so of the caption matter of 9/6/2010, Malad, of the caption subject requesting you to take steps for withdrawal of the suit or proceedings in Guwahati and arranging for the collection of title deeds. But those are the letters, Malad. And Malad, kindly see the third paragraph. We have on date received, but kindly see how the bank had actually taken care of the title deed in their custody. We have on date received the folder file containing the title deed relating to Selim TSA, another thing that they have given them. And found the noting on the folder that the title deed relating to Fattichary estate have been filed in court on so and so date. We understand the suit bearing so and so filed in the court of subordinate judge Agartala, Tripura by erstwhile UBIL on September 27, 1986. We presume that they acted in the presumption that the same may have been filed And this is the way they have treated with the title deed. The same may have been filed in the suit at Agartala. We as such request you, the one official is requesting the other, once again to take steps for arranging filing of the joint compromise petition before DRT Guwahati and to take steps for obtaining the title deeds from Agartala. Once they said it was filed in Agartala, was Guwahati, but by virtue of a noting, then they thought, no, it was from Guwahati, it had come to Agartala in a separate proceeding, it has been deposited. So to take steps for obtaining the title deeds from Agartala court of the DRT Guwahati on urgent basis, and as the party is pressing hard for release of the original title deeds. This is the stand taken by the bank itself, Malad. Meanwhile, we are delivering the title deed of Selim T estate, Malad. So, admitted, Malad, kindly see, Malad, I would like to rely upon, Malad, 2 orders passed by this honorable court, Malad. One is the, Malad, it is of all 2015, and Malad, all these observations, Malad, has attained finality, Malad. Of one is of, Malad, 29th April 2015. Passed by Honorable Justice Orijit Banerjee, Malad.
Have you got copies of those or extra copies?
Malad.
For the timing, please hand up this one.
May I, Malad?
That is the only copy you have? Acha, I've got the copy.
Ma'am.
Fair. Yes. 29th April.
First one is 29th April, my lord.
Yes.
But kindly see, my lord. The writ petitioner obtained loan from United Industrial Bank Limited for running the tea estate by name of Phottichera Tea Estate situated in Agartala. The writ petitioner deposited with the industrial United Industrial Bank Limited as collateral security the title deed pertaining to Phottichera Tea Estate and also the Salimil Tea Estate, which also belong to the petitioner. The writ petitioner has paid off the dues of the respondent bank. There is no dispute on that score. No due certificate has been issued by the respondent bank. However, the respondent bank has not returned to the petitioner the original title deed pertaining to Phottichera Tea Estate. Mr. Court, learned senior counsel for the petitioner has drawn the attention of the court to an internal correspondence of 8 July 2010, my lord. But it is that very correspondence I have just shown to your lordship, my lord. Written by the Assistant General Manager, Head Office of the Respondent Bank to the Assistant General Manager, Zonal Office, Calcutta in this regard. Once the dues of the Respondent Bank have been paid, it is the bounden duty of the bank to return the title deed pertaining to Phottichera Tea Estate to the writ petitioner. The bank cannot have any excuse at all for not returning such title deed. But it is submitted from the bar on the behalf of the bank. The title deed may have been submitted to the Court of Subordinate Judge Agartala, before whom the title suit bearing number so-and-so was instituted by United Industrial Bank Limited. However, it is pointed out by Mr. Kaur that upon United Industrial Bank merging with Allahabad Bank was substituted as a plaintiff claimant in the said suit, title suit. Hence, it is the obligation on the respondent bank to return the said title deed to the writ petitioner. But kindly come that this is unfortunate situation. Mr. Kaur is apprehensive that the original title deed is not returned and the original title of the state will remain effective. Thereafter, bank was directed to explain as to why the original title, the last paragraph of the same page, why the original title deed pertaining to Phottichera Tea Estate is not being returned to the writ petitioner, and also narrating as to what steps have been taken by the bank to locate the said title deed. Affidavit was directed to be given. The after affidavit, this is the last order, my lord. This is the next order, my lord, of 17th August 2015, my lord. But as the owner, the second line, my lord, as the owner of the Phottichera Tea Estate, writ petitioner created equitable mortgage in respect of the said tea estate in favor of the United Industrial Bank Limited bank by depositing the original title. May kindly come to my lord. But the page 3, my lord, the last paragraph of page 3, internal page 3.
I'm reading that only.
My lord.
Yes,
Having
read
heard
it out, please.
the learned counsel for the parties and having gone through the writ petitioner and the other pleadings, my lord, it appears that there is a real problem in hand. The original title deed pertaining to Phottichera Tea Estate cannot be traced out. However, in my opinion, since undisputedly the writ petitioner deposited the title deed with the predecessor in interest of the respondent bank, it is the duty and obligation of the respondent bank to return the original title deed to the writ petitioner, and in the event the original title deed cannot be located, then to make over the petition to the petitioner a certified copy of the title deed after obtaining the same from the appropriate authority. If this is not done, the title of the writ petitioner in respect of the said tea estate will remain imperfect. And that's why, my lord, today, my lord, I cannot, my lord, use even the land, my lord, for taking mortgage or for getting financial assistance.
You have transferred it to Kamala Tea Estate.
No, my lord, it could not be, my lord, without the title.
How can you take mortgage?
Let them, my lord, then show the document. If I have, my averment is
They
there.
will show the document.
Averment is there, but it could not be, my lord. And that's why, my lord, lordship has found the reply, my lord, taken, my lord, to the reply. In reply, it is categorically said no transfer could be effected.
In reply, you have taken a stand which is contrary to your earlier stand before a different tribunal.
But that was the subsequent stand, my lord. In reply to their assertion, my lord, it was made, my lord, that at least it was made before your lordship clear on affidavit that it could not be transferred. But kindly, my lord, thereafter, my lord, accordingly, the respondent bank is directed to take necessary steps for obtaining a certified copy of the title deed pertaining to Phottichera Tea Estate, and after obtaining the same, make over such certified copy to the writ petitioner. The writ petitioner bank shall extend all cooperation to the respondent bank for the purpose of obtaining such certified copy. The exercise should be completed within so and so. My kindly, the next part is very important, my lord. At the request of both the learned counsel, the writ petition is kept pending so that the further order may be passed, if necessary, in case the certified copy of the title deed cannot be obtained. That was relating to my claim of compensation.
Who said that? That was relating to claim
Something-
compensation?
Anyway.
No, my lord, I was there, my lord. He was not there. It was
But
not
what
relating
is
to
written,
compensation
my
at all.
lord? What is
It
written,
was to
my
be
lord?
heard, my lord. This cannot be
What
said,
is
my lord.
written, my lord?
That was
But
related.
may I, my lord?
No, the honorable judge does not say it was
So,
relating
my
to
lord,
compensation that it
after
was
the
pending.
affidavit, my lord, bank had taken all the stands in the affidavit, my lord, everything was
Has to be
considered, and
finally
thereafter
decided
this
to-
order was passed. Bank did not, after the affidavit, when the matter was heard out, bank did not assert any point of mentality as he is now attempting
Yes, yes,
to
it's there in
escape.
my affidavit in opposition. What is
No,
my
no,
learned
thereafter
friend
this
saying?
hearing was held.
The hearing is being held today also. It is
Yes,
not
yes, that is
disposed
my
of.
point.
Yes, that is my
And
point.
this is the order, my lord. They have not taken any challenge, or they have not
Not
taken
required.
any dispute to that order in any manner available to them. My lord,
Pass my order now. I'm sorry.
but on that score, my lord, that leading
Let
to
me
the
pass my
stand.
order now. Yes.
But allow me tomorrow to come back with the
Learned
instruction.
counsel for the petitioner
And no conveyance was done, my lord.
This is reliance on a supplementary affidavit filed in court to indicate that there are several documents of payment of taxes, revenue, etc., which indicate that the petitioner is the owner of the property. Full stop. It is further submitted that despite several directions of court, the Allahabad Bank, in which the original bank where the property was mortgaged has merged, has failed to obtain certified copies and or hand over the original title deeds which were mortgaged, which were kept, deposited with the bank. Full stop. Next para. Learned counsel appearing for the respondent bank places reliance on the annexures to the affidavit in opposition of the bank to indicate that the present writ petitioner had itself taken a specific stand that on or about January 1, 1995, January 1, 1st January, January 1, 1995, the concerned tea estate, namely Fatik Cheda, FATICKHERRA, tea estate, was transferred to the transferred by the writ petitioner to one Komola Tea Company Limited. Full stop. It is submitted, by further placing reliance on land revenue records of Tripura to indicate that the said tea estate has also been recorded in the name of Komola Tea Company Limited. Full stop. As such, it is argued that the petitioner does not have any locus standi as of today to prefer the writ petition, claiming either the title deeds or compensation in lieu of non-production of such title deeds by the bank. Full stop. Next para. Learned counsel appearing for the petitioner controverts such submission and places reliance on two previous orders passed by coordinate benches in connection with the present writ petition. Full stop. In the first order dated April 29, 2015, it is pointed out, the court had clearly observed that the respondent bank has not returned the original title deed pertaining to the said tea estate to the petitioner. Full stop. It was further observed by the learned single judge that it was an unfortunate situation, and the learned advocate for the petitioner was apprehensive that if the original deed was not returned, the writ petitioner ' title deed to the said tea estate will remain defective. Full stop. Next para. In a subsequent order dated August 17, 2015, the same learned single judge, upon hearing both sides, comma, was also clearly pleased to record that the respondent bank was to take necessary steps for obtaining a certified copy of the title deed pertaining to the tea estate concerned, and after obtaining the same, comma, to make over such certified copy to the writ petitioner. Full stop. Next para. Hence, comma, it is argued that there is no scope of reopening the issue at the present juncture, comma, at the final stage of hearing. Full stop. Next para. Learned counsel for the petitioner also relies on the affidavit in reply filed by the petitioner in such context and submits
At para 5, page 10.
submits that in paragraph number 5,
Page 10, my lord, the 4 lines from top. The portion that I had.
do you have a seat behind you? Take it. Put the microphone off. That the কোনখানে ছাড়লাম এবার? In paragraph 5 of the same, comma, the petitioner categorically denied that it had admittedly transferred the tea estate to Kamola Tea Company Limited, and that the writ petitioner no longer owns the Fotikchera tea estate as alleged or at all. Full stop. It was further averred in the said paragraph that the respondent bank has prevented the petitioner from transferring Fotikchera tea estate and stroke or has affected the marketable title of the said tea garden by reason of non-return of the original title deed. Full stop. Next para. By placing reliance on such averments and arguments, comma, it is contended by the petitioner that the previous averment of transfer in favor of Kamola Tea Company, comma, has to be read in the perspective of the subsequent documents of payment of revenue by the present petitioner and the subsequent averments made in the reply to the writ petition. Reply of the writ petition. Full stop. Next para. Upon hearing learned counsel for the parties, comma, it is seen that no final adjudication was made in the orders passed by the coordinate bench, comma, which have been relied on by learned counsel for the petitioner. Full stop. In the order dated April 29, 2015, comma, affidavits were directed at an inchoate stage. Full stop. The learned single judge had narrated the case of the parties and had directed affidavits to be filed in the matter. Full stop. Next para. Insofar as the subsequent order dated August 17, 2015 is concerned, comma, the bank, comma, through its counsel, comma, had specifically submitted that the writ petitioner had no locus standi, has no locus standi করে দেবেন, has no locus standi to maintain the writ petition, comma, since it appears that the Fotikchera tea estate has been transferred by the writ petitioner to one Kamola Tea Company Limited. Full stop. Of course, comma, the factum of such transfer of the tea estate was disputed by learned senior advocate appearing for the writ petitioner, who submitted that although such transfer had been contemplated, comma, the same could not be carried through because the original title deed pertaining to the Fotikchera tea estate was not available. Full stop. Next para. The learned single judge observed, comma, after hearing learned counsel for the parties and going through the writ petition, comma, that there was a real problem in hand. Full stop. It was further observed that the original title deed pertaining to the tea estate cannot be খুঁজে পাওয়া যাচ্ছে না, traced out, full stop, in the opinion of the learned single judge, comma, since undisputedly the writ petitioner deposited the title deed with the predecessor in interest of the respondent bank, comma, it was the duty and obligation of the bank to return the original deed, comma, which cannot be located. Full stop. Next para. Upon a careful perusal of the said two orders, comma, it is seen that although certain observations were made by the learned single judge, comma, the averments made by the present petitioner in its objection before the concerned debts recovery tribunal were not placed before the learned single judge and or considered while making the observations in the order dated August 17, 2015. Full stop. It was mere submissions from the bar that were considered, and at that juncture, comma, when the writ petition was still pending, comma, the matter had ultimately been directed to be listed subsequently for orders. Full stop. Next para. However, comma, at the stage of final hearing of the writ petition, comma, such finding per se cannot operate as res judicata. Full stop. Next para. At the stage of hearing, comma, it is the charter of the court to look into all documents and pleadings of parties and to arrive at independent findings on the basis of materials on records and arguments made by parties. Full stop. Next para. What is evident from the affidavit in opposition of the bank is that one of the annexures thereto clearly indicate that the present writ petitioner in an application under section 22 of the recovery of debts dhar due to banks and financial institutions act, comma, 1999 had categorically admitted that the defendant number 1 therein stroke petitioner stated that on or about 1-1-1995 Fotikchera Tea Estate was transferred by the defendant number 1 stroke petitioner to Komola Tea Company Limited. Full stop. It was further iterated that transfer of the said tea estate by the petitioner to the said Kamola Tea Company would inter alia appear from certain letters which were referred to in the said paragraph. Full stop. Again, comma, in a written objection used by the defendant number 1 stroke present petitioner in OA case number 196 of 9 OA case number 196 of 1999, comma, it was categorically averred by the petitioner in clause 4 within bracket small h that the applicant bank that the bank within bracket applicant therein bracket closed was fully aware of the fact that the Fotikchera tea estate was already transferred and the same was no longer in the control, comma, management and administration of the defendant number 1 stroke present petitioner. Full stop. Next para. Again, comma, in paragraph number 7 of the same opposition, comma, it was reiterated by the defendant number 1 stroke petitioner that since it was no longer in control, comma, management and admission of business of the tea estate, comma, the question of payment of proceeds of teas to the bank and stroke or of there being any hypothecation of teas, TEAS, teas in favor of the bank did not and could not arise. Full stop. Next para. Even from the extracts of the documents of the revenue subdivision Mohanpur in the revenue district of West Tripura, comma, a copy of which has been annexed at page 65 of the opposition of the bank in the present writ petition, comma, item number 5 clearly indicates that Photikchera Tea Estate had Kamala Tea Company Limited recorded as its owner. Full stop. Next para. In the reply, comma, the present petitioner has sought to refute such contentions merely by denying the same and stating that the respondent bank had prevented the petitioner from transferring the tea estate in question and Strokor had affected the marketable title of the tea garden by reason of non-return of the original title deed. Full stop. Next para. However, comma, the submission made by counsel on behalf of the bank on August 17, 2015 before the writ court through counsel, as well as the statement made in paragraph number 5 of the reply of the petitioner are patently contrary to the stand taken categorically by the petitioner in its earlier pleadings before the Debts Recovery Tribunal. Full stop. Next para. Since the said averments were earlier on point of time, comma, the presumption is that those, comma, having been accepted and acted upon by the DRT, comma, were correct, comma, unless clearly rebutted by subsequent evidence to show that those were incorrect. Full stop. Next para. A mere bald statement subsequently made in a reply to the writ petition, comma, which was itself filed much subsequent to the proceeding before the DRT, and submission made through counsel cannot rectify such situation for the petitioner. Full stop. Next para. In fact, comma, the corroborative evidence appearing from the materials on record as discussed above, comma, clearly shows that the petitioner did not and does not have any locus standi, comma, after its admitted transfer of the Photikchera Tea Estate in favor of one Kamala Tea Company Limited, comma, on January 1, 1995, comma, to stake any claim to return of the documents and stroke or any compensation, comma, as indicated by the petitioner through counsel, comma, in that regard. Full stop. Next para. Hence, comma, the entire exercise undertaken throughout in connection with the writ petition now appears to be futile. Full stop. The petitioner, comma, not having locus standi to prefer the present writ petition, as on the inception of the writ petition itself, comma, the present matter does not justify any positive result for the petitioner. Full stop. Next para. Accordingly, WPA 303 of 2015, along with connected applications, comma, if any, comma, are dismissed on contest without any orders to cost.
Lord, only my affidavit in reply to the supplementary affidavit, Lord, I'm just keeping it on record.
I'll come to it. প্রথম সেন্টেন্সে সবকিছুর আগে একটা লিখে দেবেন affidavit in reply to the supplementary affidavit filed today be kept on record. Yes.
Affidavit in opposition, not
I'm sorry.
opposition.
To the supplementary evidence.
Yes.
Stated that. Yes. You are missing out the points. Yes.
Since my lordship has found that the petitioner presently has no locus, my lord, would it be a pleasure to your lordship to record, my lord, that this order, my lord, would not
This will affect everything.
but the Kamlati to assert, my lord, that portion.
Lord, why? Kamlati is not before lordship, they should have added.
He's right. He's right. Why should I preclude commodity also? Act a line add করে দিন last. You cannot have it both ways, Mr.
Not at all, Lord. They should have added, Lord,
It
Kamlati.
is made clear that nothing in this order shall bind any non-party to the present writ petition, and if Kamala Tea Company Limited asserts its rights independently, comma, the said entity would not be debarred from doing so by virtue of any of the observations made herein.
We shall also try, my lord, if we can get something, my lord, we will write to them. I don't know.
2015 despite
It
several
affects.
orders,
Thank
We
you.
shall also try.
deeply obliged, my lord.
Yes.
Grateful, my lord.
Thank you.
Grateful.
Got it.
Item number 13, CSC.
Well
Limited
tried,
versus-
well tried, but you have a chance in appeal probably. And you learned senior counsel is
That
there.
appreciation, yes, that I was just immediately saying.
While he was reading the order, just suddenly came back, but I never knew that it was transferred to Kamala Tea.
No, you objected because there was nothing on record also at that point of time.
Now, my lord, before, my lord, I take your lordships to the main matter.
Yes.
Lord, there were certain documents, my lord, which were left out at the stage of affirming the writ petition. I have filed and prepared a supplementary affidavit. I'm seeking leave to file this
I'll
supplementary.
grant you leave. Have you given a copy to him?
Yes, Lord, I have given it to him, but I've given it to him today in court.
So if you want to use anything against this, I can.
Just one notification I would like to.
Supplementary affidavit.
Yes, let him make him. We have been briefed. I am led by Mr. Dheeraj Trivedi in this matter, my lord. We have the brief at 10:30 today, my lord.
If you want to use anything against this, use it. Unnecessarily, I'll not hear.
No, this is
a
Lord,
supplementary affidavit. my lord.
supplementary affidavit to the writ petition.
Alright.
Just one, Lord, I'll just rely on one gazette notification, which
Oh,
was
very
left out in the petition.
Yes.
Lord, this is a writ petition by the CESC Limited. Lord, they lay cable, underground cable, for the purpose of supplying electricity to this city. Now, Lord, along with this cable, they also use an optical fiber cable. Now, this optical fiber cable, they have been using since about 1996. Prior to that, this cable, this particular method, Lord, was not available. This cable was not available. So, Lord, the advantage is that when this fiber optical cable is inserted along with the cable, what it helps is it gives, Lord, an indication in case of cable fault, where exactly the approximate location, not the just the point, but approximate location. It also, Lord, helps. Lord, for example, when the Majorhat bridge fell, Lord, the entire electricity supply was affected. It helps to find out which are the routes by which, Lord, the electricity can be restored. By, Lord, keeping, Lord, the portion which is affected, Lord, as it is.
This can be tracked.
This can be tracked.
Right.
So basically, Lord, this is communication which, Lord, the CSC offices receive as a network. So, Lord, therefore, this portion, this communication portion, was held to be an act, Lord, under the Indian Telegraph Act. It was held to be they are doing something which is, Lord, offending the Indian Telegraph Act. This happened, Lord, way back in 1996. So, Lord, at that time, the 48 Act was available. They had taken, the CSC had raised initially a plea that's under section 42 of that Act. They have a right to, Lord, install this fiber cable. But, Lord, that was negated. They had to take a license. The license fee is about 2% of the total, Lord, cost of capital that they incur in laying the cable. This is the calculation. This was continuing. Now, Lord, then came the 2003 Act. Now, Lord, if your lordships kindly, Lord, take the 2003 Act once. Lord, please come to section 277 first. Section 277, section 2, the definition section. Your lordships, please come to 77.
Yes.
The definition of works, it says includes electric line and any building, plant, machinery, apparatus, and any other thing of whatever description required to transmit, distribute, or supply electricity to the public and to carry into effect the objects of a licensee or sanction granted under this act or any other law for the time being in force. Then, Lord, please come to section 67. Lord, 67 is not very important. I wouldn't come to that. 164. Kindly come to section 164.
Yes.
It says exercise of power of telegraph authority in certain cases.
Yes.
The appropriate government may, by order in writing, for the placing of electric lines or electric plant, for the transmission of electricity or for the purpose of telephonic or telegraphic communications necessary for the proper coordination of work, confer upon any public officer, licensee, or any other person engaged in the business of supplying electricity under this act, subject to such conditions and restrictions, if any, as the appropriate government may think fit, to impose and to the provisions of the Indian Telegraph Act 1885. Any of the powers which the Telegraph Authority possesses under that act with respect to placing of telegraph lines and posts for the purpose of a telegraph established or maintained by the government or to be established, etc. Now, Lord, your lordships will find there is a delegation, Lord, under the 164
Yes.
to the appropriate government.
Mr. God, before going into the Telegraph Act, I'll come back in 10 minutes.
Yes, yes, of course, of course.
Please give me half a minute, please. Yes.
But for my satisfaction, the Lordships kindly looks at section 164 once again.
Definitely.
Lord, 164 is a delegation under the Electricity Act given to the appropriate government for the purpose of placing electric lines or electric plant for transmission of electricity or for the purpose of telephonic or telegraphic communications.
Yes.
Necessary for proper coordination of works conferred upon public officer licensee or any other person engaged in the business of supplying electricity under this act. So basically, the power under the Indian Telegraph Act could be conferred even on a licensee for both, for supply of electricity as well as for the purpose of telephonic or telegraphic communications.
Right.
Now, Lord, vis-a-vis this, kindly take a look at section 42 of the Electricity Act. It shall be the duty, 42.
Yes.
It shall be the duty of the distribution licensee to develop and maintain an efficient, coordinated, and economical distribution system in his area of supply and to supply electricity in accordance with the provisions contained in this act.
Right.
This is not an obligation which is cast upon the licensees to develop and maintain an efficient, coordinated, and economical distribution system. 42.1 is sufficient. Other portions are not relevant for the time being. Now, Lord, in exercise of this power conferred under 164, a notification has been issued by the state government because, Lord, the delegation is on the local government.
Yes.
The Lordships may kindly, Lord, take the supplementary affidavit and come to page 13. Lord, in case, Lord, there is some your Lordships can't read the document, then, Lord, I'll hand up, Lord, I've got a fresh copy.
No, it's all right.
On the left-hand side, I find that there may be little difficulty. I really don't know whether your Lordship's copy, your Lordship can read. No. Jodi পড়তে পারেন, ঠিক আছে.
Can be decided.
In case your Lordship has any difficulty, I'll place, Lord.
Yes, definitely.
May I place this, Lord, notification? It is dated 16th August 2005. Post, Lord, the act coming into force.
Yes.
Whereas CSC Limited, having its registered office at CSC House, Chorungi Square, Kolkata, is a public limited company registered under the Companies Act 1956 and a licensee engaged in the business of distribution and generation of electricity under Electricity Act 2003. And whereas CSC is required to establish distribution system and undertake supply of electricity through its distribution system. And whereas placing and maintaining of electric lines or electric plant under, over, along, or across posts or upon any immovable property for the supply of electricity or for the purpose of telephonic or telegraphic communications necessary for proper coordination of works, the vesting and exercise of power of Telegraph Authority under Part 3 of the Indian Telegraph Act with respect to the placing of the telegraph lines and posts established or maintained or to be so established or maintained are required to be conferred on CSC. Then, Lord, the operative portion. Now, therefore, in exercise of powers conferred by Section 164 of the Electricity Act, the CSC is hereby authorized to exercise all powers vested in Telegraph Authority under Part 3 of the Indian Telegraph Act 1885 in respect of the electrical lines and electrical plant established or maintained or to be so established or maintained for the supply of electricity or for the purpose of telephonic or telegraphic communication necessary for proper coordination of the works within the licensed area of CSC. Now, Lord, my status as a licensee, it's my contention, has changed by reason of this notification. Because, Lord, I became an authority under the Indian Telegraph Act, Part 3. Now, Lord, your Lordships may kindly take the Indian Telegraph Act. Achi?
Yes.
Thank you. Lord, your Lordships may kindly, first of all, take Section 4 or not the definition of telegraph that is there in section 3(1)AA.
Yes.
Lordships will find means any appliances, instrument, material or apparatus used or capable of use for transmission or reception of signal, signs, writing, images, sounds or intelligence or any nature by wire, visual or other electromagnetic emissions, radio waves or Hertzians, waves, galvanic, electric or magnetic means. And then Lord, please see 4, it says 4 is exclusive privilege. And it says within India, the central government shall have the exclusive privilege of establishing, maintaining and working telegraphs, provided that the central government may grant a license on such condition and in consideration of such payments as it thinks fit to any person to establish, maintain or work a telegraph within a part of India. So, my lord, so long I was a licensee, this section 4 was applicable. Now, my lord, when I am made an authority under part 3, your lordships may kindly come to section 10. Kindly come to section 10.
Yes.
10 and 11 is material for our purpose because blood power under part 3 is given. All the powers blood that is exercised by the telegraph authorities under part 3 is given by this notification. So blood it says the telegraph authority may from time to time place and maintain a telegraph line under, over, along or across and post in or upon any immovable property provided that shall not exercise power conferred by a section. The rest is not. This is the power of the telegraph authority which is not delegated to CASC. Now, my lord, the dispute that is there in the petition today, my lord, for the purpose of interim order, I'll restrict myself to the short point. The dispute is that, lord, for all these years, the telegraph, the central government, the telephone department, or lord, the Department of Telecommunication, they have been raising bills as licensees and we have been paying. This has continued even despite the fact that this notification was issued. Lord, we have continued. But Lord, so far as the last demand is concerned, this is Lord 31st January, which is at page 61.
Yes. 61.
Yes, this is the demand plot which is raised on 31st of January 2023. Has your lordship got that?
Yes, yes.
It says provisional bill for advance payment of royalty charges for establishment and maintenance of optical fiber communication links in and around Kolkata amounting to rupees 18 lakhs raised based on project cost conveyed under your letter, etc. is forwarded herewith for payment of the same within the due date, that is 25th of March. And Lord, this is for the period 23 and 24. This bill was raised. Now, Lord, sorry.
Yes.
Now, Lord, the CSC, Lord, made a representation at page 63.
Yes.
We refer to the provisional bill dated 31st January for payment of subject royalty amounting to such and such as forwarded under cover of the communication bearing such and such. An optical fiber network serves the purpose of maintaining coordination between our generating stations and the substations and distribution station. Maintaining an efficient, coordinated and economical distribution system is a duty cast upon the distribution licensee under the provisions of the Electricity Act 2003. An optical fiber network is therefore required for distributing and supplying electricity and also facilitates carrying into effect and implementing the objectives envisaged in the Act. Thus, such a network is an integral part of a distribution licensee's work. Under the provisions of the Act, a distribution licensee is empowered to lay and install its works. The provisions of the Act are in the nature of non-obstante and have an overriding effect over any other law in force. Thus, the empowerment of the distribution licensee to lay and install its works cannot be subjected to regulatory view of any other law, including Indian Telegraph Act 1885. A distribution licensee is therefore not required to obtain a license under the provisions of the Indian Telegraph Act for the purposes aforesaid. Hence, a distribution licensee is not under any statutory obligation to pay royalty license fee as a term or condition of such a license. Now, my lord, after this, there is another letter. Just I place that letter and then make my submissions. That is page 64. Yes. Now, my lord, your lordships can skip the first two paragraphs because it is reiteration of what is there. Kindly come to the last one. Over the years, royalty charges have been paid and multiple requests for extension for OFC network has been received from CSC Limited. Since the OFC network is currently in use at your end, you are once again directed to pay the royalty charges for financial year 2003-4. Any failure to pay the royalty charges will lead to violation of the terms and conditions of the permission letter dated 17 December 1997 of Department of Telecommunication. Necessary action shall be initiated. Now, Lord, two things. First, Lord, whatever has happened in the past has happened. But Lord, question is, today, Lord, the question that is raised is whether, Lord, in law, they can demand any license fee for up after, Lord, 16th of August 2000.
This license fee is being claimed under the Telegraph Act.
Under the Telegraph Act.
Under which provision, Mr. Kaur?
Lord, 4. Section 4.
That 4.
Like there's a provision for charging royalty, Lord, under section.
Right.
Section 4, your lordships will find. That's why, Lord, I showed section.
Yes, right. You should.
Lord, this is, Lord, qua licensee. But, Lord, when I am exercising power under the Telegraph Act, whether, Lord, I still remain a licensee. Lord, I can't be treated as both. Lord, either I am an authority, Lord, under the Indian Telegraph Act, or, Lord, I am a licensee, Lord, under the Telegraph Act. But, Lord, once, Lord, under the Electricity Act, this power is delegated to me.
Why do you say that, Mr. Kaur? Because why can't both capacities run together?
Yes, I'll tell your lordship why. Because, Lord, then this notification would have no purpose at all.
Suppose, Mr. Kaur, we forget about the Electricity Act for the time being.
Correct.
There is one a licensee under the Telegraph Act itself, under Section 4.
Correct.
Some licensee is there.
Yes.
That licensee itself, if it is designated as the authority also, is there any bar of functioning in two capacities?
Then, Lord, he doesn't remain a licensee. My humble submission would be that I can't be an authority and licensee both together. The purpose of this Indian Telegraph Act is that there is no unauthorized use and royalty is paid to the authority for, Lord, having control over its jurisdiction. But this jurisdiction, part of this jurisdiction, when it is conferred on me by a delegation, and this delegation is, Lord, beyond any doubt that, Lord, under the Act, this delegation has been made. Lord, I can't be made to suffer for as a licensee. Lord, today, Lord, the issue is, Lord, I am, Lord, exercising power for both my work in laying down the cable, etc., supply of electricity. And this is, Lord, in coordination and maintenance of for the purpose of coordination and maintenance of the electricity line, which is, Lord, the purpose under the Electricity Act, that I am, Lord, I have to put this electric fiber.
Charged doubly in the sense that you are acting as an authority and you are functioning in that capacity, but also a license fee has to be given by you,
which I am saying that I am not liable to pay license fee after the 2003 Act. Once I am appointed as an authority, because Supply Act 1948 contained a different provision. There, Lord, there was no such provision. I had to take, Lord, the authority from the central government. The central government didn't agree. I was put into the status of a licensee. I continued to pay him, Lord, as my license fee. But, Lord, and even, Lord, it is a fact that even after 2005, I went on paying, presuming that I am a licensee. But, Lord, question is today, if I am raising a point today, it's a point, legal point, which I am raising. I am saying that if I am appointed as an authority, do I still have to pay a license fee? This is, Lord, the short point, and on which, Lord, I am seeking a stay of this demand. Because this demand is from 1st of April 2023 to to 31st March 2024.
What about you're paying for so long? You accused to it.
Lord, I have,
It's a question of law, that's why.
I have accused whatever I have paid. But Lord, in so far as the future payment is concerned, I am entitled to raise a dispute, Lord, with regard to the entitlement of the Union of India to charge this.
But your cause of action arose in 2005 itself.
Yes, it did.
So
it
how
did.
do you overcome that?
Lord,
We are in 2023 now.
Only thing is, Lord, it's a statutory provision. My accusing with us with certain provisions of
For
law.
18 years you have paid.
Lord, before 2005, Lord, really, I am not raising any question because
No. Even from 2005.
2005, Lord, I have
18
paid.
years after that.
I have paid. But Lord, question is, Lord, do I have to still go on playing? It's a question of legal issue. I am raising a legal issue, Lord. It's one thing to say that I am asking for refund of money, which is not
Ask for
refundable.
that. The next step will be there.
No.
That's a logical corollary.
No. That can be decided by your lordship that, Lord, beyond 3 years, I can't ask for refund. There is no difficulty.
Very good.
But question is today, Lord, if I am raising, Lord, there is no.
Why should it perpetuate a wrong? I mean,
Yes,
there is a legal wrong.
absolutely. There's no estoppel against. Lord, there's a statutory, the law operating.
No.
I cannot, Lord.
Cannot be established against it.
There can't be an estoppel. There's one thing is that I can't be. There's a bar on me to ask for refund. I'm not saying that there is no bar.
Apart from the last 3 years.
Apart from the last 3 years. But that is also at the lordship's
Very well,
discretion.
yes.
I am not, Lord, money is not the consideration.
No.
It is here, Lord, the principle.
Future money is considered.
Future money is the consideration.
Very well.
Future money is the consideration. Lord, just two facts I must tell your lordship. After this 2005 notification, there was, Lord, a further license, Lord, which was granted to me. Your lordships may kindly see that, Lord, I was notified as an infrastructure provider category of licensee. Page 66. After the initial license, Lord, in 1996, this was a further license which was given. Kindly take the first paragraph of this document. It says that this is to certify, etc., is registered as infrastructure provider category 1 to establish and maintain the assets such as dark fibers, right of way, duct space, tower of the purpose of grant on lease, rent, sale basis to the licenses of telecom services licensed under the Section 4 of the Indian Telegraph Act 1885 on mutually agreed terms and conditions. Now, Lord, this is for the purpose of, I have entered into 2 agreements, one with Vodafone, one with, Lord, the Tata Sky. And Lord, I am permitting them to use a portion of this optical fiber for the purpose of telecommunication. Now, Lord, telecommunication, as your lordship has seen, it comes within Section 164. But Lord, I say that this is again a debatable issue because, Lord, this is a commercial exploitation, may not be wholly for the purpose of my supply of electricity, maintenance and supply.
You have both ingredients.
I have both.
Your optical fiber has both ingredients. So why not you are functioning in the same capacity, I mean, in the same breath as an authority under the Electricity Act? That optical fiber, when it is used for electricity, yes, authority. But for the purpose of telecom authorities, this Telegraph Act, you are operating as a telecom authority or distributed to telecom service provided to telecom authority. So why not you, for that component, why not license fees should be charged?
No, absolutely. Your lordship is very right. Very right.
How do you overcome that?
I have made an alternative pleading. My first contention is,
if it could be segregated, Mr. Cord, it's a different aspect.
It is segregated. It can be segregated. This is possibly segregated.
At the point of grant of license, how can it be segregated?
No,
because
this is
technology is infinite. I mean, it's new technologies are coming in.
But
5G, 6G, God knows infinite G will come.
If they give a hearing, then we will be able to convince them that it can be segregated. But Lord, my first point is, even for that, I don't need to take a license. If your lordships, please come back to the Gazette.
The only thing in this registration certificate at page 66, Mr. Cord, which vitiates it, is the spelling of Kolkata. Absolutely. The spelling of Kolkata irks me very much.
Absolutely.
Kolkata.
that
Because Mr. Trivedi is appearing, he has to answer for this.
this has become a vital point now.
Yes, this is the most crucial point, but otherwise you have both components.
Now, my lord, I just answer the last query of your
Please,
lordship.
please.
If your my lord kindly takes the notification, or rather, I start with section 164 once again. I'm sorry, my lord, I'm troubling your lordship.
No question of trouble. This is a very interesting point.
Yes, in fact, I found that there has been no other case. Lord, I was trying to lay my hands on. If your lordships kindly sees section 164.
Yes.
It says the appropriate government may by order in writing for the placing of electrical lines or electrical plant for the transmission of electricity. This is one. Or for the purpose of telephonic or telegraphic communications. Necessary for the proper coordination of work conferred upon public officer, licensee, or any other person engaged in the business of supplying electricity under the Act, subject to such condition restriction, if any of the appropriate government may think fit to impose. But Lord, I also indicate that it is, if your lordship reads the later part, says for the proper coordination of works conferred upon any public officer. For proper coordination of work. Communication necessary for proper coordination of work.
But it ends with supplying electricity under this act.
Yes.
So that is what goes against it.
Absolutely.
So
I will
related back to electricity.
Correct. I will try to,
Right.
but I must be fair to the court that it's my reading of this statute is not different than what your lordship reads. But Lord,
And Electricity Act, whether it can confer powers and for telecom authorities under the telecom under a different act, that there is
I bow down to that. But Lord, that is an area where Lord, we will have to go back to them for the purpose of hearing, because the demand has been raised for the entire network.
But
If
you
you're-
can't get any stay at this stage.
No, correct.
Go on paying.
I kindly will not
It's subject to whatever.
have a look at the network once, which is at page 53. Kindly will not come to that network. I must place the entire facts to your
Oh,
lordship. Lord.
absolutely. You do please.
This is the page 53.
Yes.
This is how the entire network is connected.
Right.
This is Lord a chart Lord prepared to give your lordship an impression as to how Lord the entire network is there. The connection is there.
Sufficiently impressed.
But Lord, when the two agreements are there, I'm not troubling your lordship with the two agreements. The schedule of these agreements clearly says how and how much is being used by these two, Vodafone and Lord the Tata Sky. So Lord, it is easily decipherable.
For the present, Mr. Court, that
Yes.
is fluid. That will depend if other service providers come in. You can extract anything and everything under that. I mean, technologies also change. So
But,
we cannot keep it at a particular fixed point.
It is possible because Lord, it is royalties paid on capital investments.
Then there has to be a change in the law. There has to be a bridge between Electricity Act and Telegraph Act as far as telecom authorities are
Lord,
concerned. Otherwise,
I say, Lord, it's not necessary because of the simple reason that as if I am given the authority of a telegraph authority, I have the full authority. I can use these cables also, Lord, for the purpose for telecommunication, etc.
your confinement is limited to 164.
164
So your bottleneck comes at 164. Your
Correct.
wide powers as an authority are circumscribed by 164 bottleneck.
absolutely.
If 164 gives you power only pertaining to Electricity Act, I mean electricity supply, then we cannot probably make that large argument that you are, for all practical purposes, even for telecom authorities, you are operating as a.
But Lord, it is this facility is being given in course of my
Transmission of electricity.
transmission of electricity.
That's true.
It is in course of transmission of
And the
electricity.
first portion of section 164 cannot be brushed aside.
Absolutely. That is the crux of the matter. So, Lord, this is where we stand. So far as the interim order is
It's a
concerned,
very arguable point. Yes, absolutely.
that's why I said that it is a very interesting point. So far as the interim order is concerned, Lord, we can secure the amount, or we do whatever your lordship directs. We can put a bank guarantee and
Pay the amount that will avoid other results. That will create complications.
Sure.
Despite whatever Mr. Mukherjee says. Yes, Mr.
Section
Trivedi.
14 point of the Telegraph Regulatory Act also be kept open, my lord, because it has been said that these disputes, my lord, should be tried there, my lord. Section 14 is very clear, my lord.
Section 14 of the
14 of मतलब
Try
ट्राई
Act.
एक्ट मतलब
Try.
मैं बोलছি Milord, it says, Milord, I render unqualified apology, Milord. Today I got the brief in the morning, Milord, and I was
what?
told,
No, no,
Milord.
just refer
So,
to the
Milord,
section,
it is just,
section 14.
Milord, because it says, Milord,
What does it say?
Milord, the central government shall by notification establish an appellate tribunal to be known as Telecom Dispute Settlement and Appellate Tribunal to adjudicate any dispute between a licensor and a licensee, between two or more service providers, between a service provider and a group of consumers, Milord, providing that nothing in this clause shall apply in respect of matters relating to monopolistic trade practices, restrictive trade practices. So, Milord, that is not. Then, Milord, consumer forum redressal, Milord. So, Milord, this point be kept open, Milord.
This is neither between two service providers nor with a consumer. And
Milord,
moreover,
we are
this is on
saying, Milord,
principles-
between the two, Milord, Milord,
service
we are on-
providers.
Yes, Milord.
Union government is a service provider for other purposes,
Milord.
not in this aspect. So it is not a service provider. Union government cannot be confined to
Licensor and
service
a
provider.
licensee.
My lord, licensor and a licensee also.
So,
Milord, I am.
And
I am
also
just-
consumer, moreover, Mr. Trivedi, this is probably on principles, on first
My lord.
principles of charging.
My lord.
I mean, so it may be scrutinized by the
Milord,
report.
my first line of arguments would be, Milord, what has fallen from my lord. And Milord, subsequently, just to buttress my contention, Milord, maybe I can take this point, Milord,
So that
whether
point-
it will be stand or not, Milord, as a matter of abandoned caution. I may also take just to buttress or icing on the cake, to put it more specifically.
How long will you take to file an affidavit in opposition?
Milord, 4 weeks.
Minimum.
Milord, 4 weeks.
4 weeks
Milord,
from today.
My lord, if my lord makes it 5 weeks, Milord, I'll be.
No, 2 weeks after
enlightened.
vacation, sufficient time.
My lord, whatever falls, my lord, I'm not bargaining at all, any cost. Whatever falls from my lord.
The learned senior advocate appearing for the petitioner raises a very arguable question as to whether the respondent authorities are justified in charging license. These are called license fees, Mr. Kaur.
Royalty.
Royalty, comma, treating the petitioner stroke licensee, comma, as a licensee in the contemplation of the Indian Telegraph Act 1885. Full stop, next para, by placing reliance on section 164 of the Electricity Act 2003, comma, it is argued that the appropriate government within bracket in the present case, comma, the state government, bracket closed, comma, by order in writing, comma, for the placing of electric lines or electrical plant for the transmission of electricity, or for the purpose of telephoning or telegraphic communications, italics শেষ, continue করছি এমনি, necessary for the proper coordination of works, comma, confer upon any public officer, comma, licensee, etc., subject to such conditions as it may think fit to impose, and the provisions of the Indian Telegraph Act 1885, comma, in our italics given, any of the powers which the Telegraph Authority possesses under the Act with respect to the placing of telegraph lines and telegraph posts for the purposes of a telegraph established or maintained by the government, or to be so established or maintained. Full stop. Next para. Learned Counsel, the Learned Senior Counsel also places reliance on section 2 within bracket 77 of the 2003 Act, comma, which defines the term within double inverted works, double inverted মধ্যে, to include electric line, etc. Full stop. Section 42 of the said Act, comma, on the other hand, comma, indicates that It shall be the duty of a distribution licensee to develop and maintain an efficient, coordinated and economical distribution system in his area of supply and to supply electricity in accordance with the provisions contained in the Act. Push up next para. Again, citing section 3 within bracket 1 caps AA bracket closed, it is argued that the definition of telegraph is very specific in the said provision. First up, reading the said provision with section 4 of the 1885 Act, it is seen that the same contemplates exclusive privilege in respect of telegraphs and power to grant licenses. Full stop. Under section 4 within bracket 1, the central government shall have the exclusive privilege of establishing, maintaining and working telegraphs, and for the said purpose, may grant a license on certain conditions. Full stop. Next para. It is argued that in the same breath, the petitioner, operating as an authority under the 1885 Act, cannot be imposed charges in the capacity of a licensee, which are mutually exclusive and contradictory to each other. Full stop. Next para. It is further contended that under section 10 of the 1885 Act, which falls within part Roman 3 of the 1885 Act, the Telegraph Authority has powers to place and maintain telegraph lines and posts. Full stop. It is argued that the installation of optical fibers, fiber technology, for the purpose of distribution of electricity, even if has a component of telecommunication, the same cannot strictly fall within the purview of the functions of a licensee under the 1885 Act. Full stop. Since the optical fiber was installed in the first place to discharge the petitioner's functions as an authority under the 1885 Act in terms of section 164 of the 2003 Act, it is argued that the said installation is not subject to being charged in the form of a license. Full stop. Next para. Learned counsel appearing for the union, Mr. Trivedi, additional solicitor general.
No, my lord, I am deputy, my lord.
Deputy solicitor general. Learned deputy solicitor general, appearing for the Union of India and the respondents, contends at the outset that the present writ petition is not maintainable in view of the operation of section 14 of the TRAI Act, TRAI, full form to Telecom Regulatory Authority of India Act. Full stop. Under the said provision, a dispute between two service providers or a service provider and a consumer is required to be resolved before the appropriate authority as designated therein. Full stop. Next para. That apart, learned Deputy Solicitor General also controverts the arguments made on law and fact by the learned senior advocate for the petitioner. Full stop. Next para. Since the present hearing is confined only for the purpose of consideration of grant of interim order, a detailed consideration of the entire provisions of law is not being gone into at this stage. Full stop. However, insofar as the argument of the respondents as regards non-maintainability of the writ petition is concerned, the same is turned down on two scores. First, it is well settled that matters of first principles and law, insofar as charging within double inverted licensee under the 1885 Act is concerned, falls within the domain of exploration of the interplay between the two statutes. Full stop. Hence, comma, the same cannot be confined to a mere dispute as contemplated in the Tri-Act to empower the tribunal exclusively to decide such issues. Full stop. That apart, comma, the present dispute is not between two service providers or a service provider and a consumer, but between the union, the central government and a licensee stroke authority under the 1885 Act. Full stop. As such, comma, it cannot be said that the writ court apostrophe S domain of judicial review is precluded by operation of section 14 of the Tri-Act. Full stop. Next para. However, comma, since a very arguable question, since an arguable question has been raised by learned counsel, comma, the writ petition is required to be heard on its merits. Full stop. Next para. However, comma, insofar as stay of further charges being levied by the respondents on the issue which is sub judice in the present writ petition is concerned, comma, the same would be an unnecessary interdiction at a premature stage. Full stop. However, comma, it is made clear that whatever charges are levied from the date of filing of the writ petition on the assumption that the petitioner is a licensee under the 1885 Act in terms of the impugned notice shall be subject to the result of the present writ petition. Full stop. All such charges paid by the petitioner will be without prejudice to the rights and contentions of the parties insofar as the present writ petition is concerned. Full stop. The respondent shall file their affidavit within bracket S within June, I'll give you till 20th June. June 20, 2023. Full stop. Reply, if any, shall be filed within 1 week. Reply shall be filed within June 27, 2023. Full stop. The matter shall be listed for hearing on June 28, 2020.
Much obliged.
ওরা কোনো বই দেয়নি? ওরা তো কোনো বই দেয়নি।
May I file the affidavit of service?
No.
I'm grateful, Millet. Thank you. My lord's leave.
কিসের? তাই একটা জানি একদম। Appellate set. Now the appellate set matters.
My lord, I dare here to supplicate your lordship's benign indulgence for the item number 19.
তুমি মেনশন গুলো কি গো? আচ্ছা দাও দে।
Appellate side, do we mention item number 1? I am for the petitioner. This matter is appearing perhaps at the instance of the southeastern coalfields. Mr. Anubhav Sinha called me yesterday that he had mentioned the matter.
Yes.
As he was facing some difficulty to file the affidavit because it was notarized in Andhra Pradesh.
Oh, yes. So that for granting that liberty.
Yes, I think so.
Mention kar rahe hain.
Then I want to file it.
It is notarized, otherwise notarized. It is notarized in Karnataka, you said? Bilaspur.
And then it has been noted in the here itself.
Before the Commissioner of Oath, it has been presented.
I just wanted to file it. It has been served to the other side. Also.
You are the respondent number?
2.
The matter is appearing under, yes?
On the last occasion when the matter appeared, we, on account of inadvertence, we did not file our supplementary affidavit that was already circulated to the parties on the earlier occasion. May I file it in court, I'm grateful.
Insofar as the supplementary affidavit is concerned, I have a small submission. On the last day I wasn't here, my learned advocate on record had made a prayer that we intend to use a very short affidavit to respond to that supplementary. And your lordships have been pleased to observe, since the counsel was not there, to renew my prayer and to keep it ready. So, my lord, may that leave be formally granted.
You'll file that it is ready.
No, my lord, it's not, because we were expecting the matter to come up on 13th, my lord, of June.
Well, right. Today it is appearing. The matter is appearing under the heading to be mentioned on the prayer of respondent number 2. Full-stop, learned counsel for the respondent number 2 submits that the department is not granting, the department is not permitting the respondent number 2 to file an affidavit in opposition affirmed by the said respondent on the ground that the same was not affirmed before the commissioner of oath of this court. First up, it is submitted that the same is notarized and has been presented before the commissioner of oaths of this court. First up, next para, since it transpires from the endorsements on the affidavit that the same has been duly notarized in Bilaspur, comma, there cannot be any unnecessary technical impediment in taking the same on record. First up, accordingly, leave is granted to the respondent number 2 to file its affidavit in opposition. First up, pursuant to such leave, comma, such affidavit in opposition, comma, filed in court today, comma, be kept on record. So next para, learned counsel for the petitioner files a supplementary affidavit, petitioners files a supplementary affidavit, which is also accepted and kept on record. Full stop. The respondents shall file rejoinder thereto, comma, if any, comma, within 1 week after vacation, within June 9th, 2023. Full stop. The matter shall be listed for hearing as previously directed on June 13th.
That's right.
On June 13th, 2023. Thank you.
Great.
Thank you.
My lord.
Do we mention item number 2?
I apprehend
This
we have
matter, my lord, I am for the petitioner, my lord. This matter appeared. But this matter appeared before your lordship yesterday under the heading motion. My lord, my service was not completed, so I sent my learned junior to seek for an accommodation on that ground. But Lord, he mistakenly, my lord, said that it is not affected upon the private respondent, although there is no private respondent.
No, it was recorded submits that the service has not yet been completed on the other respondents, although WBACTCL.
No,
all of them are.
WBACTCL is the only.
Very good. So, what is this? Affidavit of service?
Yes, my lord.
Achha. The matter is appearing under the heading to be mentioned on the direction of court, comma, since it was discovered subsequent to the order dated May 17, 2023 being passed that there was no other respondent apart from the WBACTCL and its officials in the writ petition, comma, although it was recorded in the said order that the service on the other respondents had not yet been completed and the matter may stand adjourned to be listed in the monthly list of June 2023. Full stop. However, comma, it is clarified by learned counsel for the parties that there is no other respondent than the WBACTCL and its officials. Full stop. As such, comma, the order dated May 17, 2023 is modified to the extent that the first paragraph thereof is deleted. Full stop. Hence, comma, pursuant to the direction given therein, comma, the matter shall be listed in the monthly list of June 2023. The affidavit of service filed today be kept on record.
Great, great.
New motion, item 3.
I am for the respondent to this matter.
Could I appear for the petitioner?
Yes, Mr.
My learned counsel, Mr. Samal Chakravarti is on his legs. I want
Mr.
Mr. Samal Chakravarti.
He's engaged in this case. He's on his legs. Just a little passover.
Little password means
5-7 minutes. That's
yes, Ms. Otto, what do you say? You cannot say anything on password.
I don't want to say also. In that case, can you take it up at 2 o'clock subject to the business of the court?
তাহলে পাসওয়ার্ড থাক 2 o'clock এটা 2 o'clock ফিক্স নেই তো 2 o'clock the first matter. This one.
Item 4.
May please, your lordship, I am for the petition. My lord,
Dr. Shire is also looking the other side, although he appeared on the last occasion.
Actually, on the last occasion, I appeared on behalf of
Somebody else.
there is a direction to make inspection and report.
Oh, yes.
Is it
Report is coming.
son and father dispute?
You are the son.
No report. No report has been.
Huh? We are agreeable to install the meter.
My lord.
Though I haven't seen that. My police help is necessary, lordship. Police
Will pay the cost. Police cost.
Any doubt regarding that, Mr. Hallar? Don't be condescending on that. I will pay the cost. You have to pay the cost, obviously. A report is filed today pursuant to previous direction by the CSC Limited, which indicates that it is technically feasible to accommodate another meter at the meter board room at the premises in question. Full stop, hence, comma, the petitioner, comma, being otherwise entitled under section of the Electricity Act 2003, comma, as an occupant of the property in question, comma, is entitled to get such independent connection in his name, despite the objection of the private respondent, comma, who is the father of the petitioner. Full stop, next para. Accordingly, WPA 10993 of 2023 is allowed, comma, thereby directing the CSC Limited to give a new electricity connection to the petitioner. Compliance of formalities.
subject to compliance of formality
Subject to
and for the
compliance.
existing service.
Subject to compliance of all formalities by the petitioner, comma, preferably within a fortnight from the date of such compliance, comma, at the existing meter board position of the premises in question. Full stop. If any obstruction is offered by the respondent number 4 and or his men and agents, comma, it will be open to the CSC Limited to approach respondent number 3, comma, the officer in charge of the Sakrail police station, comma, who will act on a server copy of this order and provide such police assistance to the CSC personnel at the cost of the petitioner. Full stop. In the event any padlock or other hindrance is put up to prevent the access of the CSC personnel to the existing meter board position, comma, it will be open to the respondent number 3 to ensure that such obstruction is removed for the limited purpose of giving access to the CSC personnel. No address to cause urgency.
Deeply aware. And let the report be kept in the record.
Achha, the report filed today be kept on record and like.
Item 5.
Appear for respondent number 5, my lord.
For the petitioner, my lord.
Yes.
That is my point of service. My lord, I have got the fact concern today only.
Can you please take the microphone once, yes. Track report shows good service.
My lord.
Very good. Track report নিয়ে না এর সঙ্গে রেখে দাও। Yes, what is the dispute?
But just like earlier.
You are the son.
I am step daughter.
A step is there in between you.
One thing I appear for the
Father.
mother.
Mother, achha.
Mother.
Genders reversed, otherwise same.
The difficulty is the present meter is in my bedroom, my lord. There is available space in the property. It should be installed.
Is there any litigation between you two? Later in the electricity.
No,
if you have chosen to put it in your bedroom, what
that was from the instance, my lord. But she is now trying to enter into my possession, my lord.
No, no, only electricity connection.
Kindly, my let the meter be shifted, my lord. Both be shifted a common place, my lord.
To pay for that, they'll shift.
Both should be here, my lord. Both should be here, my lord.
His meter is in his bedroom and I have to install it in another place.
No, no, bedroom, the privacy may be affected by it. So if they were shifting, if you agree, ask your client, if your client agrees, I'll direct shifting charges to be borne by both of you. I think that will be easier for all of you.
My lord.
It can be shifted. An inspection and we find that there is a resistance from the private respondent.
Did you find a common space? No, nothing regarding that. That was not directed.
We couldn't make an inspection because it is under the bedroom.
You did not let them.
Well, that was in my bedroom, my lord.
Do something. You shift to a common area and leave the bedroom for the electricity meter. The petitioner is the stepdaughter of the private respondent.
Number 5.
Number 5. Full stop. When the petitioner applied for a new electricity connection in her name at the premises in question, comma, where both the said parties reside, comma, the respondent number 5 raises an objection on the premise that the existing electricity is situated in the bedroom of the respondent number 5, full stop, as such, comma, if a new metered connection is given to the petitioner from there, comma, the privacy of the respondent number 5 will be directly affected. Full stop, next para. Learned counsel for the CSC Limited contends that the meter position could not be inspected due to resistance put up by the private respondent number 5 and her men and agents. Full stop.
Intimated them by a letter.
Which has been intimated to the parties by a letter. Next para, give a copy of that letter. A copy of the said letter filed today in court is kept on record. Push up next para. The contention of the petitioner, comma, on the strength of section 43 of the Electricity Act 2003 is that as an occupant, comma, she is entitled to an independent electricity connection at the premises. Full stop. Upon query of court, comma, learned counsel for the CSC Limited agrees to the meter being shifted to an alternative common location, comma, subject to availability of such location at the premises. Full stop. Upon further query, comma, it is submitted by learned counsel for both the petitioner and the private respondent that we are willing to bear equally the expenses for shifting of the existing meter room position containing the meter of the respondent number 5 and about to contain the meter of the petitioner, comma, to some existing common position at the premises. Full stop. Hence, comma, there cannot be any further impediment in doing so. Accordingly, WPA 11678 of 2023 is disposed of by directing the CSC Limited to hold an inspection within a week from date upon further prior notice to both sides for the purpose of ascertaining a common location for shifting the existing meter board position at the meter board of the premises. Full stop, next para. Such inspection shall be held in presence of both the parties and or their representatives. Full stop, next para. Upon such inspection, comma, if it is found feasible, comma, the CSC Limited shall shift the meter room shift the electricity service at the premises from inside the bedroom of the private respondent number 5 to some external location within the premises, which is a common location according to both the parties. Full stop. Such exercise shall be completed upon a due application in that regard being made by either the petitioner or the private respondent number 5 and or both jointly, comma, which also has to be made within a week from date. Full stop. Next para. Upon the compliance of all formalities by the petitioner as well as the private respondent number 5, comma, the shifting will be completed and simultaneously a new electricity connection shall be given to the petitioner by the CSC Limited, comma, the entire work being mandatorily completed within 3 weeks from the date of compliance of such formalities by the petitioner and or the private respondent number 5. Full stop. It is made clear that in the event the private respondent number 5 does not cooperate in such shifting charges being paid, comma, after dividing the same equally between the petitioner and the respondent number 5, comma, the petitioner will be at liberty to deposit the entire amount and recover the same in due process of law subsequently from the respondent number 5. Full stop. However, comma, such technical issue should not be an impediment in the direction of this code being complied with. No address to cause urgency.
But they have to apply afresh. Just now your lordship has put down that.
They will have to apply for shifting.
Shifting.
That electricity supply application is already there.
So
They have to apply afresh, either him, or, his client, or his client, or both together can apply for that shifting. The payment will be made by them after that, by both of them equally. If they do not cooperate, then Mr. Chatterjee, you are Mr. Chatterjee? Mukherjee, sorry. Mr. Mukherjee's client is entitled to pay the entire amount, deposit the entire amount, so that the electricity connection is not, and he will recover from it.
And if necessary, lordship, police help can be given if they register. If there is police help is necessary.
We are ready to comply with it.
Police help, lordship.
Arta line thala add kore din. In the event any obstruction is raised from any quarter to the CSC personnel undertaking the job as indicated above, comma, it will be open to the CSC Limited to approach the respondent number 4, comma, that is the officer in charge of the Charu Market police station for adequate police assistance, which will be given by respondent number 4 by acting on a server copy of this order at the cost of the petitioner. Full stop. If, comma, for such purpose, comma, any padlock or other hindrance is required to be removed, comma, it will be open to the police personnel to remove such padlock or other hindrance for the purpose of implementing the direction of the court.
Deeply of lordship.
Thank you.
Item 6.
For the private.
For the petition. License.
License, yes. You are for the private respondent? Right. Yes, what is the matter, Mr.
Prisoner 4.
Prisoner, yes.
Yes.
Yes, Mr. Chakravarti, what is
A
it?
new service connection, my lord. The petitioner is the owner of the plot in question, my lord. My lord, the difficulty is this: the private respondent preferred a suit before the learned trial court, my lord, and there they obtained injunction, but there is no such injunction to the tune that not to give electric connection to the premises of the petitioner, my lord.
Not to change the nature and character of the property.
Well, that I have already stated in my petition, my lord, but I have applied for the service connection.
It is called injunction.
Injunction.
Injunction restraining you from changing nature character.
My lord, start
To private respondent. Also against the petitioner.
Yes, restraining them from
Independent
changing nature.
Lordship.
So,
now
yes, why?
I
They are
can-
not, yes. Why are you not giving?
My lord, in this matter, I have taken instruction, my lord, just I have received the.
We have got instruction just now by the submissions. Yes, what is?
Lordship, there is one thing.
You're too tall for the microphone, take the microphone above. Yes.
Actually, they are making fraud deed. Thereafter, they making
Their
application.
Their position is undisputed.
No, position is mine, Lordship.
No, no,
Because of the
position,
fact,
because
they are-
you
they
have
are-
filed a suit. Acha, in that
Yes.
suit, have you got a copy of that injunction order?
Injunction order, but
I have not annexed, my lord.
What is the suit for? Tell me first, what is the suit for?
injunction, declaration and injunction. Suit for? The suit copy not annexed, my lord.
Don't have a copy of the plate. Don't have a copy.
I'm just received yesterday. That's why I'm not.
But your learned friend has received much back.
On yesterday.
He also received yesterday. He gave you yesterday. He received much back.
I have received today, Lordship.
You, not
Yes.
him.
His client received yesterday, Lordship. Can you give the track report and can you show the track?
Come back tomorrow.
My lord.
Lordship, tomorrow. Because of the, this matter, no?
No, it's a electricity matter there without
Lordship,
electricity.
no, because of the fact, their Lordship, they have tin shed, and that they are claiming that is a workshop. That is not a workshop, Lordship. And it is a classification of the land is bagan, garden. Lordship, kindly for a moment, kindly be aware, this is they are making, everything is clear. They are making mutation in favor of the, after hearing mutation case number such and such,
File an affidavit in opposition on the reopening date.
1 week after, Lordship.
No. Without electricity, these people are without getting 3 weeks for drafting.
Lordship, there is no, they are claiming that is a workshop. There is no workshop. There is a.
Since you have to annex to the, you have to annex the plaint, written plaint, the injunction order,
Application order.
this and whatever else you have.
Lordship, kindly 3 days, at least, Lordship.
I'll give them that time, Mr. Court.
Lordship, as
Learned counsel for the
Yes.
respondent. Auditor for
And I have filed my affidavit of service.
right. আচ্ছা প্রথমে লেখো affidavit of service filed to be kept on record, full stop. Learned counsel for the petitioner contends that due to resistance of the private respondent, comma, the electricity connection cannot be given to the petitioner in the petitioner's name. Full stop. Learned counsel for the WBACDCL seeks some time to take instructions. Full stop. It is submitted by learned counsel for the private respondent number 4 that the petitioner has obtained certain documents by fraud, full stop, that apart, comma, the private respondent number 4 has filed a civil suit where an injunction order has been passed restraining the petitioner from changing the nature and character of the property. Full stop. It is further submitted that there are certain orders passed by other authorities which are also required to be brought to the notice of the court, comma, since they are germane. Full stop. In any event, comma, neither the plaint nor the order of injunction or any other document is a part of the record. Full stop. To bring such documents on record and to permit the parties to make their respective pleadings, comma, the respondents are directed to file their affidavits in opposition within June 9, 2023. Full stop. Reply, if any, shall be filed by 3 days or 1 week.
3 days.
Reply, if any, shall be filed within June 14, 2023. The matter shall be listed next on June 15th. I've given you 1 week after the vacation.
Sure.
Passover matter, item 3.
Yes.
May it please your lordship. Your lordship was pleased to direct the CSC to make an inspection and file a report.
Yes.
No, we have filed on the last.
Last topic.
Yes. But we have received copies also.
Yes.
But from the report, it appears, my lord, there is a space which have been found out where, my lord, all the meters can be shifted.
What was the dispute, Mr.
My lord, the dispute was, my lord, disconnection. So, this is the third disconnection. And therefore, my lord, your lordship was pleased to, my lord, direct the CSC to cause an inspection to find out either or whether my connection can be shifted to another place or all could be shifted to a common place. Now, they have found out a common place which is beside my shop, which would require, my lord, closure of one of my windows. I don't mind. I don't mind.
As we disconnect, Mr. Chakraborty.
My lord, I am, my lord, filing an exception to the report, my lord.
What is the basis of that exception, Mr. Chakraborty? What have you taken?
First of all, my lord.
Yes.
This is a recurrent writ petition. In the previous writ petition.
Yes.
Similar order was passed for inspection, and on inspection, report was submitted that there is no common.
Mr. Chakraborty, please take the microphone a bit closer to you.
My lord, in previous writ petition, my lord, an order was passed for inspection.
Yes.
An inspection was held and report was submitted that there was no common space available for altering the meter board, my lord. In the present case also, my lord, the report, my lord, report has been submitted, which cannot be, my lord. দেখবেন বলে আপনার কপি তো দেবো এনে
Exception copy you are giving now, Mr. Chakraborty?
Just yesterday, my lord, your lordship report was given.
Oh, then you could not help it. Yes.
My lord, kindly see the present report, my lord, kindly see
Yes.
whether it is permissible, my lord.
Right.
Paragraph 3 of the report.
Paragraph 3.
Present report, my lord, present report.
Yes.
During inspection, the petitioner's representative showed us a space. During inspection, petitioner's representative showed us a space inside their office room for shifting of their meters, which is technically not suitable. Next, however, during inspection, CSC found a suitable space wherein all the existing meter can be shifted on the outside wall of the office chamber of the petitioner facing towards the common passage. For this, petitioner has to construct a meter board shed by removing the window of the office room wall. Whether I should be, my lord, compelled to remove the window of the.
You are not the petitioner.
No, my lord, window. I am the owner of the property. My lord,
petitioner is a tenant.
Tenant, not also tenant. The father and mother of the petitioners were tenant, admitted in the writ petition, both died long back. 2G also applies, my lord, they are in occupation. This is their status. So whether I, being the landlord, is may be compelled to remove my window for the benefit of the tenant. Well, this is the question to be decided by your lordship. And in the previous report, previous in connection with the other writ petition, previous writ petition was filed.
Previous report I don't have.
My lord, I have annexed with my exception, my lord.
As per my knowledge goes, I may be wrong, but we have not submitted any report in any writ petition.
এটা কোনটা?
I may be totally wrong.
কোনটা?
রিটের অ্যানেক্স আছে যেটা হিয়ারিং দিয়েছিল শিফটিং এর জন্য।
It is already annexed
in the writ petition. Shifting এর জন্য হিয়ারিং হয়েছে।
Let a copy be at least served on
Give a copy, Mr.
এটা কপি তো নাই
Chakraborty. If you're relying on extra documents.
আমার তো কপি
হ্যাঁ ও একটা অন্যদের দিতে হবে। I shall give, my lord.
Give a copy, come back tomorrow then.
This is the question.
They're without electricity. Oh no, they're getting electricity disconnected, being disconnected.
They are, my lord, no, my lord, they have got their meter. My lord,
you are disconnecting every time.
No. And my lord, whether, my lord, I am supposed to, my lord, shift my meter also at the disposal of the tenant.
If you do disconnect continuously regularly, then yes.
So that I shall face the consequence, my lord, if I
This
disconnect.
is the consequence. Your window will be removed. Tomorrow your bedroom will be
Your
removed.
lordship, my lord, is a civil judge, my lord, for all through, my lord, I know
Mr.
that.
Chakravarti, but I'll make it very clear in my order. Let it be after the vacation, but I'll make it very clear that in the meantime you will not. The parties have to maintain status quo regarding the existing connection.
Yes, yes. That's
But I am being
Definitely,
disconnected.
right,
So
sir.
I don't stand to
Present you are enjoying.
No.
Oh, you are without electricity.
Disconnected on 4th of January of this year.
Then
Well, for restoration, I have
Mr. Mukherjee, let us come back tomorrow then. They're without electricity.
no, my lord, for restoration, my lord, I cannot stand in the way, my
No, my instruction is from our end, it is like, when a later copy will
Then how the difference is coming, my lord?
No, they are saying that you have internally disconnected. And
no,
they
no.
are saying that the connection is live from there.
Yes.
So internally,
If your
very well,
lordship
I'll permit the petitioner then to have it restored through their people.
I do not mind.
In the meantime, subject to result of.
ইলেকট্রিক সাপ্লাই ডিসকানেক্ট করো আমরা করি
না না
না, না,
তোমার মক্কেলের আপত্তি নেই তো
না না ইলেকট্রিক সাপ্লাই ডিসকানেক্ট করো ওরা করবে তো restore,
দাঁড়াও,
আমরা
দাঁড়াও।
করতে
we have
Miller-
never disconnected.
Miller, only to refresh your lordship's memory, page 231 of my writ petition.
ক্লায়েন্টকে জিজ্ঞেস করো না, জিজ্ঞেস করো না।
Miller, in the previous inspection, please have a look to clause E.
Kit Kat fuses.
Yes. Now, unfortunately, we have to come to this court,
No, I am
to
told,
High
my
Court
lord,
for all
they have
these things.
got two connection, one regarding shop and another regarding residential unit. I'm told that regarding shop, is connection is there. Regarding residence, no connection is there, I
Yes.
suppose.
Yes.
It is told, it is told,
Why was the connection not there? Because previously it was found that Kit Kat fuses of the main switches were missing.
my lord,
No.
it has been burst out. Be that,
Very well. That will be taken. I'll give them leave to have it repaired,
Yes.
whatever Kit Kat, whatever.
yes,
If
yes,
necessary, they can seek help of the
yes,
CSC
yes, my lord,
if
definitely.
necessary.
Miller, I'm told that I am not getting access to that place.
Madam, kindly come to what Mr. Dotto has said, madam, kindly come to clause B at the same page.
D.
B,
Yes, sir.
till
No,
meter.
that I've seen. That
Madam, whatever has happened in respect of the portion of the.
is there any civil suit pending? There is a civil suit.
Two suits pending, one for eviction, the other for Miller injunction.
So you can take your get your reliefs regarding this from the civil code also
This
for the
is a-
time being.
This is a separate cause of action, Miller.
True, this is a separate cause of action, but for this disruption, you can claim your rights there also. But this is individual dispute. How can I direct police help for that? A civil suit is pending between you
No, Miller, for the Miller, going into this
for
report.
repairing the Kit Kat.
Yes, for repairing the Kit Kat, Miller, please, Miller, permit us to have a police assistance only for this limited purpose. It will take maximum 1 hour, I say.
My lord, we are not opposing that.
In that CSC has got no
No,
part.
CSC will not do anything.
No, if you oppose, Mr. Chakravarti, if you're not opposing, it's well and good. If you oppose by any chance, then I'll give them liberty to approach the police.
In case of, yes.
Then police. I'll record a submission that you will not oppose. 100% opposition. 100%
I
opposition.
cannot, my lord,
You cannot improve anything.
yes, my
You
lord.
cannot improve anything. Neither of us can. Learned counsel for the private respondents files an exception to the report filed on the last occasion by the CSC Limited. Full stop. A copy thereof is handed over here and now to learned counsel for the CSC. Acha, a copy thereof has not yet been handed over. Not yet been handed over to learned counsel for the CSC Limited. Full stop. Let a copy be handed over during the course of the day by the learned advocate on record for the petitioner to his counterpart appearing for the CSC Limited. Full stop. Next para. Since the CSC Limited seeks some time to have instructions on the exception and the document annexed thereto, comma, the matter is adjourned and shall next be listed in the monthly list of June 2023 Full stop, next para. In the meantime, comma, however, comma, since the petitioner is without electricity due to certain internal issues, such as the KitKat fuses, KitKat a single inverter, KitKat fuses at the main switch being missing, comma, the petitioner is permitted to take appropriate steps to repair the said defect and restore the electricity connection internally within the premises. First up, in the event the petitioner is obstructed in doing so, comma, it will be open to the petitioner to approach respondent number 4, comma, the officer in charge of the Bhawanipur police station to give adequate police assistance on the basis of a server copy of this order at the cost of the petitioner for the purpose of enabling the petitioner to repair the said KitKat and or other defects which may have occurred internally, comma, for the purpose of restoring the petitioner's electricity supply for the present. Full stop. Next para. However, comma, such repair work shall not in any manner prejudice the rights and contentions of the parties in the writ petition itself. Full stop.
I'm grateful, man.
But only one thing, Milord, if I may only request your lordship, Milord. Now this KitKat system has gone. But if I may replace it with we all use now MCP switches. Yes. If I may replace that.
Replace bolechi. Repair the KitKat bolechi. And or যেখানে repair the KitKat and or put in some alternative equivalent mechanism suitable to current technology.
Without causing damage to the.
No, definitely not. This will be without prejudice to your rights.
But only one thing, where now, Milord, we are facing some problem regarding getting server copies. Where the police to act on the basis of lawyers' communication.
আচ্ছা, যেখানে বললাম যে acting on the server copy of this order and stroke or communication of the gist of the order by the learned advocate for the parties.
Well, I'm grateful.
But window removal, Mr. Dotto is, I mean, I don't think I'll allow it. Because he's the landlord, he's right on that. For a change, Mr. Chakravarti is right.
I'm grateful, man.
Yes.
Item 7.
Yes, sir.
Petitioner, my lord. Item 7, my lord, I am appearing on behalf of the WBSCT.
Now, my lord.
Any private respondent?
No, my lord.
What is the matter?
So, my lord, the matter is, my lord, that a exorbitant bill of 3,71,000 has been issued in favor of my client. My client is the owner of this property, my lord.
Go to the grievance redressal office.
If it is at all, my lord, kindly see the portion, my lord, at page 14, my lord, kindly comes to page 14 once.
Page 14, yes.
Yes, my lord. Top, my lord, invoice number, something thereafter. Previous meter reading date, my lord. 19/7/2017. Present meter reading date 2/12/2022. In between, my lord, they have not come to my residence for meter reading. And curiously enough, my lord, kindly come to page 13, my lord. Lordship will find the meter has been installed on 12/11/2017 at the bottom, my lord. Kindly see, my lord.
Yes, yes.
2017, and first meter reading date is 19/7/2017. And next visit is on 2/12/2022. In between, nobody is there, and all on a sudden, my lord, 3,71,000 bill has been issued.
Yes, what is this?
Yes, lordship. Actually, what happened, lordship, domestic connection for domestic, it was applied. Thereafter, service connection was provided, having completed all formalities. Thereafter, what happened, my lord, due to some problem, MasterCard, as per report, lordship, MasterCard of the said consumer was not appended. And thereafter, lordship, what happened, installation number was not generated. And the petitioner was not on the premises. But important thing is that there is a tenant, lordship, and that was used by that tenant. It was discovered that on the November 2020, it was discovered that consumer is unbilled, but consumer unit number, consumption of the unit is 39771, which was displayed on the meter board. And bill, on the basis of that, bill was generated. And
How could
subsequently,
the first reading date be in July when the
yes,
connection was given on 12th of November?
yes.
How?
Whatever I said, Lordship, before your installation number was not generated due to the master card of the said consumer was not appended.
No. You said that previous reading date is 19th of July 2017.
Yes.
The connection was given in November 2017.
Yes.
How could it the first reading be 4 months before that?
That instruction has to be.
The thing has to go. You reassess bill, proper bill, and not only that, you have to disclose the basis of your calculation. Because for so long you have not been taking meter readings, you have to disclose the basis of your calculation. I'll leave it open for them if there is a billing dispute, further billing dispute to approach the GR. But this has to be set aside. He's right.
Lordship, one thing, may I mention, Lordship, just on that part, it has to be taken the instruction, Lordship, kindly permit.
What instruction? 19th of July 2017 cannot. Take your instruction, ask your officers to take instruction the next time you are doing it. Let them approach you first, contact you, take your advice, and then raise the bill. Lordship. The petitioner has raised a strong issue as to the bill raised for electricity charges by the WBSEDCL being patently and palpably erroneous. Footstep next para, placing reliance on annexure P1 at page 13 of the writ petition, comma, it is contended that the electricity connection itself was given to the petitioner on November 12, 2017, comma, which is evident from the meter reading card annexed. Footstep next para. However, comma, in the impugned bill dated December 2, 2022, comma, all on a sudden, the WBSEDCL has raised a bill of rupees 39,771. No, sorry.
No, but 3,71,015.
Yes, 3,71,371,015. Full stop. Next para. It is rightly submitted that the previous reading date shown in the said bill is July 19, 2017, comma, which is impossible in view of the connection itself being given only on November 12, 2017. So that apart, comma, the present reading date as appearing on the bill is December 2, 2022, comma, which is about 4.5 years after the previous reading date, comma, which is itself suspect. Full stop. Next para. In such view of the matter, comma, upon hearing learned counsel for the parties, comma, it is palpable that the impugned bill dated December 2, 2022, annexed at page 14 within bracket annexure P2 bracket close of the writ petition is patently perverse and erroneous. Full stop. Hence, comma, WPA 11735 of 2023 is allowed, thereby quashing the impugned bill dated December 2, 2022 and directing the WBSEDCL to raise a fresh assessment bill, comma, disclosing therein the exact methodology and basis of calculation of raising such bill for the relevant period. Full stop. In the event the petitioner has any further grievance on such fresh bill raised by the WBSEDCL, comma, if any, comma, the petitioner will be at liberty to approach the concerned grievance redressal officer with such grievance. Full stop. If so approached, comma, the grievance redressal officer shall decide the same in accordance with law upon giving opportunity of hearing to all concerned. No rest to cause charges.
Grateful.
Why did he have the brilliant idea of engaging you? Why did he have the brilliant idea of engaging you in a electricity?
No, I have not appeared before his lordship.
For that opportunity.
But affidavit service filed to keep to that.
No. How can it be kept on?
Affidavit of service.
Definitely.
Grateful.
Item 8.
8.
Yeah.
You are for the
Petitioner,
petitioner,
my
must be. You are for the distribution
This
license.
is third times, my lord. Come before your lordship.
Why your fault or court's fault or their fault?
Now,
All their fault.
comply to your lordship order.
Achha.
First order, my lord, your lordship.
What
page
happened?
24. Ordering position, my lord. 26, my lord.
Yes.
Your lordship directed, as per your lordship direction, two landowner applied, but they have, the state city distribution company not raised any outstanding dues, my lord. Thereafter, my lord, I moved and I read application. Page 28, my lord.
Let me just go through my previous order.
Yes, yes.
Yes. What happened after this?
Thereafter, my lord, you can see page 28, my lord. Two owner applied and they have given electric line. Your lordship order. Your lordship kindly see the next page 29, your lordship order. However,
Because that was without prior notice.
yes, madam.
On that ground. Yes.
However, it is made clear that in the event, my lord, in the event there was no grievance with the non-compliance of the order, so developer, contract, consumer to be open to giving prior notice to the petitioner and other concerned consumer as well as the developer indicate the default having completed by them. Next with my
What have they
30,
done now?
my lord 30, thereafter it is penalty. So my lord, you also kindly see page 31, my lord. They have raised bill, my lord.
Yes.
To 2,24,000, my
They
lord.
have complied with the order.
I have complied your lordship order.
Yes.
I have deposited, my lord.
Right.
Thereafter, my lord, they have issued one quotation, my lord, for consumption for connection electric bill, my lord.
One?
Page 34, my lord.
34 years.
Actually.
Another bill.
No, quotation for transformer.
Quotation.
For installment,
For installment of
transformer.
electricity.
Installation of the
Transformer.
My lord.
That is different thing. That has nothing to do.
Page 35, my lord.
Yes, 35.
Page 35. This is the next copy, my type copy, 35A. Paving, my lord, 6,99,000 for the cost of transformer, my lord. Thereafter, my lord, again, I have made a request. Thereafter, again, another question is sub, my lord. Page 36, my lord. Where is a raised quotation only 4,81,000.
So you are agreed with the reduction
Yes, my
of the
lord.
amount?
I have made representation, my lord. You also kindly see page 37, my lord.
No, previously they raised 6 lakh something, then it came down to 4,81,000. So you write again, it will come down to 2 lakh something.
Page 37, my lord.
37.
Whereas is a nearest pole, Sauda potato stores from property, only 3 poles is required, my lord.
We cannot decide the.
You so my lord, you also kindly direct.
How
You also kindly direct to consider my.
We cannot do it, Mr. Chakraborty.
And
How
give
can
a-
the RIT code assess the cost?
Quotation, my lord. What is the cost? So I come before your lordship.
I am not an expert in the field to assess the exact cost.
Stating report, what is the cost?
They have disclosed their charges, pay that.
No, my lord, there are two costs already, my lord. They have here. One 6 lakhs, the other 4 lakhs. And the other should be 2 lakhs, my lord.
I can fully appreciate your situation, but Mr. Chakraborty,
Because
that is
I have
required.
already
This
paid.
is a public authority. I mean,
I have already, my developer, I have already paid my 2,40,000, my lord.
That was the
yes,
bill,
but
lordship.
that is
all
a
clear.
different. Yes.
So you
Those are clear. There is no doubt on that. But transformer charges have to be. And Mr. Chakraborty, the law is that they will install the transformer, give connection from there to you. If
Yeah.
subsequently they give connection from that transformer to somebody else,
Yes.
then they'll be, you will be entitled to refund of that limited amount, pro rata basis. That's the regulation probably.
30 flat owners of that building are to use and enjoy
Yeah,
from
how
that.
many apart?
30, 30.
Sir,
He's a developer.
You know, we
Client is
decide.
a developer.
They are putting you in the front every time.
Yes, 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 my lord.
And the developer is putting you, Mr.
Yes,
Chakraborty, in the front. No, you have to pay this. How can it be, I mean, how can we be relieved from paying this? Transformer 30 people, you won't pay this amount.
But they have not disclosed what is the amount, what is the.
They have
collection, my lord.
disclosed clearly.
You know, so can you see page 36A,
36 years.
the quotation amount. Not disclose the cost for other things. Distance or poles, what
You have
is pole?
admitted in your page 37 communication. Thereafter, you submitted one application to get the transformer to supply electricity. They are charging for that.
Yes,
They're entitled to charge. You have to pay it.
Inspection was done. He was present in the inspection.
Ah, yes, yes.
Inspection, he
Yes,
was-
my
No,
lord.
no, Mr.
And
Chakraborty. No,
I am
this.
requesting one. Pay before lordship.
No, not in this.
If possible.
That counsel for the petitioner submits that this is a third round of litigation. First up, after the prior 2 rounds of litigation and orders being passed by the writ court, lastly, the WBACDCL has raised a quotation, pursuant to which the petitioner has already cleared the outstanding dues and the charges for taking electricity connection. Full stop, however, when the petitioner subsequently applied for getting a transformer for the purpose of such supply, the WBACDCL raised exorbitant charges. Full stop, upon a request of the petitioner to reconsider the same, the charges were reduced to rupees 4,81,980. Full stop. It is argued that the petitioner, after payment of the entire area dues, is not in a position to bear the astronomical amount as charged. Full stop. As such, it is submitted that the amount may be reconsidered and reduced. Full stop. Next para. Learned counsel appearing for the WBACDCL submits that upon the request of the petitioner, there was already a reconsideration and the amount levied for installation of the transformer is the amount actually required for such installation. Full stop. Next para. Upon hearing learned counsel for the parties, it is evident that the parties complied with the previous orders of court. Full stop. In fact, all other dues have been cleared by the petitioner, but for the charges required for installing the transformer. Full stop. Next para. It also transpires that the WBACDCL conceded to the request of the petitioner for a reconsideration and reduced the charges for installation of transformer. Full stop. However, since the WBACDCL is a public authority, in charge of supplying electricity to the public at large, a further reconsideration cannot be directed within the limited scope of the writ petition. Full stop. In any event, the regulations provide that if subsequently the said transformer is used for giving electricity connection to a third party, in that event, the petitioner would be entitled to have a refund on pro rata basis. Full stop. However, at the present juncture, since the WBACDCL has assessed in accordance with law the charges for installing the transformer, which is payable by the petitioner, there is no scope for interference with the said decision of the WBACDCL. Full stop. Accordingly, WPA number 11799 of 2023 is dismissed on contest without any orders to cost. Sorry, Mr. Chakraborty.
Now, well, give direction, my lord. I am ready to pay, my lord.
Pay it, they'll install. There is no allegation on that.
You didn't pay it, my lord. Not given.
There is no apprehension that they will not give.
Again, I come, my lord.
We have raised the quotation only for that. For
No,
the
we
making
need pay
payment.
the,
Once payment is made,
I will pay the quotation amount, my lord.
Pay it, they'll be install the transformer.
Item 9.
Yes, Your Lordship, I appear for the petitioner. I have served, and this is my affidavit of service. I've served everyone.
And I have got instruction to appear on behalf of CSC.
Lordship, now,
Instruction means you're not ready.
Yes, yes.
now, Lordship, I am challenging
Yes.
the installation of a meter in.
Acha, this Salkia jute pressing, they have been served.
Yes. Yes.
Yes.
That is Lordship. I am one of the directors on Shalkia jute pressing only. It is a pro forma response. Yes.
Yes. Yes.
Now I'm challenging, my lord, the installation of a meter. Your lordship will find the meter at page 87, annexure P10. This meter has been annexed. This meter has been installed, lordship, in the name of Ayub Khan. That is the respondent number 4. The said Ayub Khan has no interest, right, title, anything in my property, and the meter has been installed in my property. I'll tell your lordship in a gist the facts. What happened, my lord? I am a lessee of the entire plot of land at 51 Jain Mukherjee Road. I've been a lessee from since 1893. I've been a lessee. Lastly,
1893.
Yes, I've been a lessee, and I've annexed 2 lease deeds that I've found, your lordship. One of 18th January 1944 that your lordship will find at page 17A. There is a translated copy of the lease deed. Your lordship will also find that at page 29. And another recent deed, your lordship will find of 31st July 1993. That is, your lordship, at page 37. Now, in terms of the last deed of lease, your lordship, 31st July 1993, it was to be effected from 1995. And I, being the lessee, I had the option of renewal of the lease every 5 years for a consecutive term of 10 times. I could have renewed the lease only by giving a notice of renewal on the lessor. Subsequently, sometime around in 2020 or 2021, the police came into my premises and said that there was an order of injunction existing, and they had come to enforce the injunction. Now, I did not know about the injunction. When I found out about the injunction, I went to the court. This is, and I found out that the respondent number 4 had filed a title suit before the against the respondent number 5. That is the Waqf estate. Now, the Waqf estate is the owner of the land, and I am an lessee in respect of the land. The lessor is the Waqf estate. What happened, your lordship? Thereafter, I went and I filed an application for impleading as a party thereof, and I have been impleaded as a party. That order also, your lordship, will find at page.
The Waqf estate filed that's an eviction suit.
Waqf estate filed an eviction suit against me in 2017 at the Waqf tribunal. Right. That is pending. So in the in 2019, what I found out in 2000
suit.
This suit has been filed out by the private respondent against the Waqf estate. Yes. Claiming that they are a tenant from 2015. I'll show your lordship why I say this. From 2015, they are claiming to be a tenant. Thereafter, in 2019, they have filed a suit that the Waqf estate is trying to forcibly dispossess them, though they were never in possession. And that also I'll show your lordship. What after that? They obtained an ad interim order of injunction. The suit is pending. I have filed a order 7 rule 11 in this regard after being impleaded as a party.
Order 7 rule 11 on the ground of non-maintainability because it is
a tribunal. Yes, but however, I filed an application under order 1 rule 10 to be impleaded as a party, and I have been, and that order your lordship will find at page 57. Subsequently, thereafter in on February 20, I'll tell you also in March 2023, 21st March, I learned that they had filed an application before the CSC, the respondent number 4, the private respondent, for installation of a meter. And I immediately gave an objection upon learning. That your lordship will find at page 85, the annexure P9. Subsequently, I told them that this is the situation. Number of complaints has been filed, and you cannot install a meter because that is my property. It is a litigated property, yes, and the title of the respondent is in dispute. Thereafter, we filed this complaint. Subsequently, they've installed this meter. Upon installation of the meter, we filed another complaint to the grievance officer, a grievance redressal officer. Your lordship will find that at page 88. Telling that they could not have, and none of our application or the written objection were considered. Now I'll show your lordship why I say this, that they could not have given this meter in his name because he was never in possession and his possession is not lawful. I refer your lordship to a judgment of a coordinate bench reported in AIR 2006 Calcutta 73. Kindly lordship comes to para 4. In my view, may I place it your lordship? In my view, the trade license does not make the petitioner an occupier or a lawful occupant of any part of the premises. On payment of requisite fees, anyone can obtain a trade license from the corporation. In my opinion, the expression occupier mentioned in section 43 of the Electricity Act 2003 shall not include an unauthorized occupant of a premises within the class of a person denoted by it. A person who forces himself into any part of a premises owned by someone else cannot be treated as an occupier of such premises.
This position has been upset now by a 3-judge bench. This position, this paragraph 4 proposition has been overruled by a...
Even so, your lordship, I'll show
now
that he was never in possession.
Now it is established that if they're in settled occupation, which is...
They're not in settled occupation, I'll show your lordship.
Yes, show that.
Yes. Lordship craved leave.
Don't rely on this because on this proposition, this has been overruled.
Yes, your lordship. I'm not, then I'm not relying on that. I'll show your lordship, the plaint they had filed in the title suit before the learned Howrah Court.
Is the tribunal,
no.
the Waqf board.
No, this is the what the respondent had filed against the Waqf estate. Yes, before the learned third civil judge junior division at Howrah.
Yes.
Lordship sure. Kindly comes to your lordship, para 1, line 7. I'm placing para 1 before your lordship, that the plaintiff is an unemployed, technically educated person and he has been inducted as a premises tenant relating to scheduled mentioned tenanted suit premises for running a meter parking business therein by the defendants, and rate of rent was fixed at 5,000 per month, payable according to English calendar month. So a backdated tenancy agreement they have created. Now, kindly see why I say this. It is submitted that there was an agreement executed by and between the parties to that effect on 6th August 2015. Kindly note this date. Now, I refer to a police report. I had filed a certain 144 applications and certain police reports have been, I have annexed them. Kindly comes to page 62 of my writ petition. Paragraph 5. This is
Cannot
the police
be heard without affidavits. Because you are on this, if you are wanting electricity connection, I would expedite the matter. But I would expedite in any event. But since this is a disputed question of fact regarding their possession. Now, definitely you are arguing that first of all, you are not a party to their suit filed against the Waqf estate. So that does not bind you.
Okay, I have become a party now. Yes, but the injunction was not on me.
Injunction was not on you. So it does not bind you.
Yes,
and you have filed an independent suit, but there is no common suit. Now you have implicated yourself as a party there. Otherwise, there is nothing common between you. No litigation.
No.
So if I hold here that they are not in settled occupation,
lordship calls for affidavit. Kindly just seize this.
So kindly see this 62.
62, just once.
Yes, absolutely.
Para 5, your lordship.
Right.
I am placing it.
Yes.
Fact is that it has been clear from the documents that except OP number 2, Sheikh Sirajuddin, and this is the Sheikh Zahiruddin, this is the Mutawali of the Waqf estate. None could be able to produce any valid document to prove themselves as Mutawali of the concerned Waqf property. Sheikh Sirajuddin was the previous Mutawali and K. Zaid and Ayub Khan, kindly notes this name, this is the respondent number 4, has no locus standi to intervene into the dispute. I found no evidence regarding the authority of K. Zaid or Ayub Khan to intervene into the issue, though they are found overactive. They even tried to cause nuisance, trying to set door at the entrance of the Waqf property, knowingly that 144 subsection 2 CRPC has already been promulgated at that premises. Though they demanded themselves to be authorized by the Mutawali of the concerned Waqf property, it is their fake and false demand. This report kindly sees at the bottom, your lordship, is on 26th February 2009.
A report filed in connection with an 140 proceeding.
Yes,
cannot
your
be
lordship,
filed.
but this records that they could not produce this tenancy document at that time.
Tenancy document, even if they're in unauthorized occupation, now the settled law is if they're in occupation.
They were
that-
never in occupation. That
but
is my
if
point.
they were
your
not
lordship.
in occupation, physical occupation, how could they cause nuisance by trying to set a door at the
Yes, they are trying to set a door at the entrance.
If they're not there, how can they do that?
They are trying to enter, and that is my point, your lordship. They are trying
They're
to
trying
enter.
to set a door from the outside.
Yes, yes. And what they have
That's
done is, they have
Very
beaten, they have beaten up my security guard. Number of times I have given complaints, I've annexed this. But lordship calls for affidavit. Only one thing, your lordship, I'll pray for an interim injunction not to give them any connection.
It
in
is
the
already
meantime.
been affected.
Has already been affected. Connection has been given to them. You are asking for disconnection in your prayer.
Yes, your lordship. I am saying that not to give further connection. And your lordship, another I have also I am praying for that the CSC may be directed to produce the documents on which basis they have given this.
I'll direct them to use affidavits also.
Yes, your lordship.
First, let me hear Mr. Mukherjee. Yes.
Only two things. One, I file affidavits. One, I kindly come to page 53. This is the suit, my lord, which has been filed by respondent number 4. On the third paragraph, 4 lines from the bottom, when the plaintiff has prima facie established his tenancy right and interest over the suit property, I think if the plaintiff is disposed from the suit property without due process.
He is not bound. Now he's trying to bind himself by getting added as a party there.
Kindly come to page 56. Not on the print which he has submitted. Kindly see the party's name.
Yes, I have been added as a party. That is the point. Kindly see page
I have
57.
not disturbed you, kindly.
At the time of filing, granting the injunction, ad interim order of injunction is extended. This extension binds you.
Yes, yes. The extension binds me.
If it binds you,
But the injunction is not on me. That is also this is
injunction extension has been passed after adding you.
yes, and we disputed it, but the learned court has passed. In any event, your lordship, we have
Now you
filed.
are a defendant also.
Yes, now I am a defendant. Added
Now that
defendant.
order binds you.
Yes, the order binds me, but I have challenged it, and the order 7 rule 11 is pending. I'm not on that, your lordship. That the court will proceed. But what the defendant is, what the respondent number 4 is trying to create a right by doing this.
But counsel for the petitioners has raised certain issues as regards the private respondent number 4 not being in possession of the disputed property. First up, despite the same, it is alleged that the CSC Limited gave electricity connection to the private respondent. First of the petitioner prays for disconnection of the same. First of learned counsel for the petitioner argues that a litigation for eviction is pending at the behest of the Waqf estate, which is the owner of the property, against the petitioner, a lessee. Full stop. Next para, the petitioner is armed with several documents to establish its lease in respect of the premises. Full stop. However, by filing a subsequent suit against the Waqf estate, the respondent number 4 obtained an injunction with regard to the property. Full stop. Although initially the petitioner was not a party to the said suit, subsequently on the prayer of the petitioner, the petitioner has been impleaded as a defendant in the suit. Full stop. Next para. It is submitted that even as of today, the private respondent is not in physical occupation of the property and, as such, is not authorized to get electricity connection at the same. Full stop. That apart, the private respondent also has no locus standi or right, title and interest in the said property at all. Full stop. Next para. I'm not saying that you have cited this. Please check up the 3-judge bench then, because this will be a unnecessary, this will be a go against you. So next para. Since such disputed questions of fact have been raised in the writ petition, the respondents are directed to file their respective affidavits disclosing their cases, full stop, such affidavits shall be filed by the respondents within June 16, 2023. Full stop, reply if any shall be filed by June 23, 2023. The matter shall be listed for hearing on June 26, 2023.
Lordship, one indulgence, Lordship kindly records that it is an ad interim order of injunction, not an injunction per se.
An injunction order বলেছি কোথাও একটা injunction বলছি তার আগে ad interim করে দেব।
May I pray for one more indulgence?
Yes.
If your lordship be kind enough to record that the extension has been, interim order has been extended after they have been added as a party.
যেখানে লাস্ট সেন্টেন্সটা বললাম তার আগে একটা আমি যেখানে পিটিশনের বক্তব্য শেষ হলো তারপরে learned counsel for the CSC Limited points out that upon addition of party as a defendant in the suit, comma, the present writ petitioner is also bound by the order of injunction passed in the said suit filed by the respondent number 4 against the Waqf estate. This much?
I'm grateful.
বলে তারপরে ওই affidavits এর direction.
Affidavit by 16th and the matter to be returnable on
16th, 23rd, 26th.
I'm grateful.
I'm grateful.
Item 10.
I beg to appear for the petition.
What about service?
Service, I'm appearing on behalf.
Private respondent?
No private respondents are there, my lord.
What is it?
But respondent number 5 has, there is insufficient service, but all are WBSCDCL.
Yes, move the matter.
My lord, I have brought this property in the year 2017. I am living there. There was an existing meter of the landlord, the previous earlier landowner. And subsequently I buy it and I was using that. And after handing over that meter, I applied for a new connection. And that is, my lord can see the deed of conveyance in the P1, page 16 to
Outstanding
29.
charges. They have claimed
They
outstanding.
have taken charge, no outstanding amount, my lord.
Very well
They have
then.
taken charges for new application. Now they are saying that there is lots of meter in the building. They cannot go into procedure A. They want to get a new mother meter and going in the procedure B. They have already taken the money receipt, that is in the page 3, my lord. Subsequently, they have sent us a letter, and in that letter, they have said that we cannot provide you the new electricity meter because there exist lots of meter and commercial activities are also doing there. But that is not true, my lord. This is a small building and I am already occupying a 350 square feet flat in the back portion of the building. My lord, kindly come to page number 33. Annexure P5, our letter. On second paragraph, my lord. I'm reading, my lord. On 22 September 2022, my client received a letter from your good office informing her that the domestic electric service connection couldn't be effected due to multiple domestic portion found. So individual connection can't be provided without installation of a mother meter through Pro B 2010. I would like to bring to your notice that my client is an individual apartment flat owner in a small 3-story building. So there is no question of applying mother meter through procedure B, as my building doesn't qualify as a multiple dwelling unit as mentioned in the application procedure B 2010. They are saying that we have to apply for procedure B for give them, and also kindly see the next page, their reply to our letter. 30 page, 35. My lord. Please note that the inspection of your premises was carried out on 21 September 2022, wherein you failed to provide access to your portion against which you have provided ownership document. Contrary to the claim made by your advocate in the said letter, your portion is prima facie observed to be a part of the G+2 building with a multiple commercial and domestic units where multiple electric connections already exist. Hence, you are requested to apply for MSC following Professor B as for norms of WSJ allow access to the entire premises for further inspection. You may apply for refund of the money against your
technical
previous
dispute. Why didn't you approach the GRO for this? This is an absolutely technical dispute. How can the writ court decide this? Even if I direct affidavits, they'll say yes, they'll stand by their own stand and you'll be standing by yours.
There already existed some old.
It's a factual dispute. Technically, whether it's possible to give it without a mother meter, because they are not saying the entire multiple other buildings. They're referring to your G+2 building only. You are admitting it's a 3-story building. 3 stories is equal to 3 G+2. So they are saying on relying on that only, they are saying there are several commercial and domestic units in that G+2 itself.
They are using already domestic connection. I was also using domestic connection till last year 2022. Now they want us to install a new mother meter.
No, 1 minute.
Entire thing.
You have already got the connection.
We had the previous connection.
What happened to it? Disconnected? Why?
We have surrendered the earlier landowner, who sold us the flat. It is the second resale
Yes, what
flat.
do you say to this? His landlord, his vendor was enjoying.
My lord.
Why do you take this new ground now?
My lord, my instructions are.
No, give connection from that line.
So that connection, my instructions are that connection does not exist, and there are multiple connections available.
There were multiple connections when his
there
vendor was enjoying.
There are still, my lord, if I may, my lord, my understanding of whatever instructions I have received as on today is that there were multiple connections which is still being enjoyed by several other occupants there, but this was prior to 2010. This is my understanding. This is what I have been instructed. Prior to 2010, this procedure A and procedure B did not exist. So this is the first new connection that is now being sought for subsequent to 2011, my lord. After this procedure has come into play. So now the regulations,
when did they apply for electricity? After 2011, naturally.
Yes, my lord.
So disclose all these documents. I'll direct them to file a short affidavit. Because if that procedure has come in the meantime, then if you apply for a new connection, now you are bound by that.
Yes, my lord, I'm bound by that. But the problem is that even if I pay, I have to pay the entire amount for installing a mother meter. And that is huge amount. Only for 1 meter, if I have to pay the
Mother
entire
meter,
amount.
what is the concept? This is like a block meter.
My lord, I haven't been able to, I have just received the notification today. I haven't been able to complete.
So if the
both
mother meter
process.
is something
My lord,
like a block meter of the CSC, then that they have to apply jointly also then. What is the rule regarding this?
Yes, they have to apply jointly, all the occupants. My understanding so far is, my lord, I am.
Mr. Haldar is an authority on this. You can take his help actually.
Main service, he's saying that main service connection for applying, there must be a main service connection. From then their submitters will be there for separate flats units.
That is already there probably.
No, my lord.
Install that meter. I mean, why not?
My lord, my understanding again, my understanding of the procedure.
Your understanding will not do. What is
My
your
lord, may
actual thing? What is the actual thing? Your understanding may not match with my understanding, which will again differ from his understanding. So how does that help you? I don't want your understanding. What is the actual fact? I mean,
may I beseech your lordship to allow me 1 day's time to come back and assist this court? If your lordship, I'll come back tomorrow.
You file your very well. Come back tomorrow if it's possible to resolve. Take instruction.
Yes.
Ask your officer if it is possible. Then give him a connection. Only one connection is wanting. Yes, purchase the property. When did you purchase?
2017, my lord.
2017. Since 5 years here, 6 years is without electricity.
No. I was enjoying the connection till 2022.
Oh,
then,
previous
year. Then the earlier meter was
that
handed
connection
over.
was in the name of the
Earlier owner, earlier vendor.
Yes. So have you stated that 2022? Where is that? In your objection, you have stated must be.
In the first paragraph, we have stated that we have brought this property and
not that. Till 2022, you were enjoying. Where have you
the
stated
petition said that on at the petitioner applied for the new domestic electric connection at the respondent number being the applicant number at accordingly computerized quotation was handed over.
You have not stated. You say that on 2nd
September, I have applied.
You applied for a new domestic electric connection. No, but till 2022, you are enjoying a previous connection.
Then I have to give some documents to show that.
Not only documents, because in 2022, you applied for the first time in 2022. Before that, you were enjoying a connection which was given prior to 2011. That you are continuing to enjoy that. That was illegal enjoyment, but you are enjoying that. That connection was there from before 2011 when A and B were not there.
Yeah.
So that was continued in 2022 when that was surrendered by you. You applied afresh, and now that rule is applicable. So he's justified on that probably.
So my lord, let me give some document, allow me to give some document to show that we are enjoying the electricity connection till 2022 or after.
Even if you enjoy till 2022, it was not a new connection
The old
given after 2011. That connection was there from before 2011. So that connection, suppose X connection, that was continuing when 2011 this A form B form came, then also that was continuing. So that A form B form provision did not apply to existing connections. That was for new connections. Now the entire thing was continuing, it continued up to 2022. So there was no occasion for them to ask for AB. On 2022, you surrendered. Now you apply for fresh connection for all practical purposes. Now it is governed by the new rules, 2011 rules. So now you are to comply with B.
But that only I myself cannot give.
No, you cannot. You cannot.
Payment.
You cannot take instruction. What can be done in this? If it can be given to them, and what is the methodology if it can be given? If all of them have to apply, he's a new purchaser in respect of one flat. How can he gather the applications from the others? They are enjoying merrily. They won't be agreeable.
My lord, in addition, the petitioner also needs to be present. I believe there's a notification where the inspection is also mandatory before providing.
No, those things can be taken care of. They'll obviously be present. But
On
whether you
last
can
occasion-
give it.
My lord, I'll take instructions and I'll come back tomorrow.
Learned counsel for the petitioner argues that the petitioner was enjoying electricity till 2022 from a pre-existing meter. However, when a new meter was applied for by the petitioner, the WBSETCL is insisting upon the petitioner applying under Form B for a mother meter. Next para, it is submitted that the petitioner is a new purchaser of only one flat in the premises and may not be in a position to get the other owners agree to a joint application for a mother meter. Moreover, the exorbitant costs payable for the mother meter would have to be borne by the petitioner then, which is contrary to the right of the petitioner to get an electricity connection at the property under Section 43 of the Electricity Act 2003. Next para, learned counsel for the distribution licensee on instruction submits that the provision as to taking a mother meter and segregation into Form A and Form B situations came into force only in the year 2011. Since the pre-existing connection was given prior to the said date, no occasion arose for submission of any B form or installation of a mother meter. However, when the petitioner applied for a new connection after surrendering the previous domestic connection, the said rules had become applicable and, as such, the WBSETCL is justified in asking the petitioner to so comply. Next para, however, learned counsel for the WBSETCL seeks a day's adjournment to take further instructions to explore other modalities by which a connection can be given to the petitioner if the petitioner is not in a position to have an application being made jointly by all the residents for a mother meter. For such purpose, the matter is adjourned till tomorrow. Recorded everything. You can show. I don't think it will be on the server by today. I don't know.
I'll communicate in writing. Deeply obliged. Your
Take proper instructions. What can be done? Till the year 2022.
Item 11.
My lord, item 11, my lord, we have received the brief today only. My lord, we have sought for instruction. My lord, kindly keep it tomorrow. My lord, we will.
Very good. You're for the licensee?
I am for the petition.
On the prayer of the licensee, the matter is adjourned till tomorrow.
You are deeply obliged, my lord.
Item 12.
My lord, in
I'm
this
for
matter, I am
the
for the petitioner.
You're for the?
I am for
petitioner.
You are the petitioner, my lord.
Yes.
There are two.
Use the microphone, please.
There are two private respondents. So till now, one has received, one has not received.
The service is not complete. Let the matter stand adjourned till after the upcoming summer vacation of this. Audit true.
Item 13,
But I am for the CSC, my lord.
But I am for the private respondent number 6.
Yes, Mr. Rai, what is
But,
your?
before the petitioner begins, my lord, may I submit item number 13 and 16?
Yes.
They are similar matters, same annexures, same parties, same prayers have been sought for. Because if one fails, the other remains. And according to my instruction, which I have received only a few moments back, that both the applications have become infructuous. Because my lord, the CSC personnel were there today upon notice, and my lord, they have already installed the new meter and the service line in the place as directed by the DM, my lord, and endorsed by this honorable court.
Yes, Mr. Rai, what do you say with the petitioner?
So for the
Infructuous or not? Not. Yes.
first thing, my lord, so far the application is concerned, I am drawing lordship attention to the order passed
16.
by your lordship, that is page 81.
Item number 16 in that case.
No.
Konta.
No, I'm taking up 13.
এটাই বলছি আমি, এটাই বলছি দাদা।
81.
This is the order passed by your lordship, my lord will sign.
Yes.
Where your lordship was pleased to direct the CSC Limited to shift the meter to the premises of the petitioner before your lordship. Private respondent deposit the money. That your lordship may read out the relevant portion, my lord. It is clear in the light of the facts of the present case, that is page 82, second paragraph. Private respondent are not interested to such shifting which is being done under the purview of the order of the district magistrate such and such. As such, the event registry awaits payment of shifting charges by the private respondents, the order of the district magistrate shall never be implemented. In such view of the matter, since the petitioner is agreeable to deposit the necessary shifting charges, there cannot be any hindrance in implementing the order of the district magistrate. Accordingly, such and such is disposed of by directing the petitioner to deposit the necessary shifting charges.
You are the petitioner there. You are the petitioner.
He is the petitioner. Upon such payment is made, CSC Limited shall implement the order of district magistrate such as by shifting the meter to the private respondent, the proposed alternative site with the fortnight thereafter. My lord, pause here for a moment, and my lord can tender the order which was directed to be implemented by your lordship. That your lordship will find. Dear. Page 66. My lord will find there is the order dated 8 December 2022.
8 December.
Page 66.
Page 66.
What is the DMR order?
DMR order that was directed to be implemented.
There is an order dated 23rd December.
Oh, two have been dispelled from my copy. That's
Two annexures, sir.
The inspection report submitted by the district inspector such and such, the said inquiry reveals that the joint inspection was carried out in the presence of such and such, has shown a new meter board shed which is already been constructed by him for shifting the service connection along with meter set. But here also,
you are Dilip.
I am Dilip. Sunanda Basu has some objection in the said meter shed is about 1 meter from the existing location. Apart from this, Dilip Kanti Roy has so far failed to provide any alternative place for shifting of this service. Now, CS has reported an alternative location from the balcony house of Dilip Kumar Devkanti Dotto. We have offered the site which was constructed for the purpose of shifting the meter. Because of the repetition in this writ application, in the earlier writ application was objected, so it was directed to be installed at the balcony of the petitioner. Though this order was passed, there is no option. That's why, my lord, the item number 16, which was filed for recalling of this order, because I am not, the petitioner was not present. The petitioner in this writ
Of
application.
my order or magistrate's order?
No, my lord's order. Unless until that order is recalled, there is no occasion.
He's right. Mr. Ghosh is right. That has to be heard first then.
Yes, that is the reason.
It has to be heard first then.
That is the reason, and my lord can take.
If I don't recall, then no scope.
There is no scope for entertaining.
Both are. I'm rejecting both together.
That, that my lord can.
Why should it be
Service
recalled?
line has been shifted and the meter has been installed.
That is different, but
That is the
The place as directed.
if I
by
recall,
the-
I'll direct that to be reshifted. Yes, Mr. Rai, let us take up 16 টা আগে বোর্ডে দেখো 13 16 একসঙ্গে দেখো কমা 16 কমা প্রভিশন আছে 13 to 16 দেখালে 14 15 নম্বর লোকেরা তেড়ে আসবে
হ্যাঁ আমার দেখানো যায়
16 এর ফাইলটা আগে দাও
মানে ওই
I'll take up
চব্বিশ
16 first, Mr. Rai.
যেখানে তোমরা দেখিয়েছো সেখানে
Nothing in it.
ব্যালকনিতে
What balcony? What is the ground for review?
not recalling that I was not order 9 rule 13. This is that is that I was a aged person. In spite of
You couldn't satisfy your learned junior that this could not be done, and you were trying to satisfy the judge.
he was very much there before the district magistrate and in all the proceedings.
Yes.
this order was passed, my lord. So, but the order passed by your lordship of the date, the petition for your lordship could
Why
not
didn't you challenge this order in appeal? My order in appeal. That was the only remedy available to you. What is the scope of recall?
recalling, my lord. So, but the expiry order, my lord, can recall on the ground that I have with sufficient reason. But so far me is concerned, my lord, not this is expertise, and this order was passed sufficient reason for non-appearing on the date of hearing of this application.
What is the reason?
That my lord will find. Page paragraph 24, paragraph 23 and 24, my lord. These are the reason. If it is convince your lordship, then there is on my question to move the subsequent writ application. If it does not, then my lord, there is nothing to.
What is your stand in the matter? No, not report. What is your arguments on this? You're appearing for the state. Give him the microphone. What is your argument on this? What is the report on?
Authority constitute the petition for causing inquiry into the matter. On inquiry, it could be learned that at present, the CESC limited yet to shift the matter.
Who inquired? The police officer inquired.
Yes, ma'am.
Para 24 is the actual paragraph, Mr. Rai.
This is a sum and substance, my lord. I cannot improve what is there apart from that. I mean, aged doctorate person, my lord, 83 years old, could not appear by on the date of hearing.
Appearing in person?
Not.
My lord, this person was having two sons, my lord.
The 83-year-old person cannot have two children.
Yes, no, my lord, I'm not saying that. This was represented by one of his sons. My lord, on all these three occasions, my lord, this is the third occasion I am moving this application. My lord, on three occasions, my lord, despite service, not appeared. DM's order was passed on December. Now, my lord, challenging the district magistrate's order.
Son signed the writ petition, the affidavit.
Affidavit, probably.
Yes.
No. I'll impose costs on the son.
Yes.
Not on you. You are 83-year-old. No.
Then, my lord, I am not.
Can 1 of 2023 is taken up for hearing? First of the same has been filed for recall of an order dated May 3, 2023 in WPA 10294 of 2023. Full stop. It has been averred in paragraph number 24 of the present writ petition, present application, that the applicant number 1 is 83 years old and is suffering from several old age ailments, and due to his deteriorating health condition, the applicants were not in a position to contest the writ petition. Full stop. As such, it is claimed that they were completely unaware of the order passed by the court on May 3, 2023. Full stop. However, it is clear from the application itself, that even apart from the first applicant, there are two other applicants who are the sons of the applicant number 1. Full stop. Next para. There is no explanation in the present application as to what prevented the said applicant numbers 2 and 3 from conducting the case effectively. Full stop. Moreover, it is rightly pointed out by learned counsel for the private respondent that learned counsel for the writ petitioner, comma, who is the opposite party herein, comma, that after several occasions of service of notice, comma, the present applicants, comma, being the private respondents in the writ petition, comma, chose not to appear, comma, for which the matter was decided ex parte in their absence. Full stop. Next para. Even apart from such factors, comma, it is seen that the order dated May 3, 2023 was passed on merits, comma, after taking into consideration all the relevant factors involved. Full stop. As such, comma, there is no scope of recalling and already recalling the order disposing of WPA 10294 of 2023. Full stop. Hence, comma, can 1 of 2023 is dismissed. Full stop. Consequentially, should I dismiss this also?
No, my lord, there is, my lord, I have prayed for shifting of the, then, my lord.
A similar
my-
prayer. Almost similar prayer, all the
Part by
annexures.
res judicator.
Yes.
But now, my lord, if the meter is shifting to the present tense past the lordship direction, my lord, I have prayed for the shifting of the same where I have constructed the.
No, no,
Yes.
that part belongs to the
Res
belongs to the opinion of the
judicata.
petitioner.
Res judicator.
My lord, that judicator, my lord, if your lordship kindly consider, this order was passed pursuant to the direction passed by the district magistrate. I have approached
My
the
lord,
district.
absolutely, my lord, the order of,
District magistrate's order is still there.
Till there, I filed an objection to that
my lord,
effect.
they have not challenged it as yet. My lord, sorry.
I have applied for the shifting of this meter prior to their application.
This
That is-
matter is why not res judicator?
My lord, this is not restricted only on the ground, my lord, if your lordship kindly consider, this is regarding shifting of the meter at the instance of the private respondent at the instance or pursuant to the order passed by the district magistrate. Now, before the district magistrate, we have filed an application that it cannot be done in the the present location where the district magistrate is directed. So reconsider the same and directed for the shifting of the meter at the place where the petitioner constructed the alternative place. That is pending for consideration. During the pendency of the consideration, which application has been moved. And it was directed by your lordship that it should be.
When did you file the application before the magistrate? After the order was passed in the writ petition?
No. It was filed, initially it was filed on, my lord, on. No. Okay. First application, my lord, your lordship find that is at page 69.
Date?
2nd December 2021. Prior to that, page 38, my lord, your lordship find.
So recall application was pending when this matter was decided.
Yes, that was.
No, my lord, that was not so. They have not placed this fact before the district magistrate. The order of the district magistrate was passed on December 22.
Yes.
My lord, after that, my lord, I filed a writ application. My lord, this is the fourth round of litigation. My lord, may I submit the facts? My lord, what had happened? My lord, initially I filed a writ application before your lordship, my lord, complaining that the meter room of the private respondents are lying in my area. Therefore, it is to be shifted. Your lordship directed the CSC to hold a hearing. CSC conducted a hearing. CSC directed them to produce the records. They could not. However, CSC said, very well, you shift the meter on your undisputed portion of land.
District magistrate order was passed when?
December 2022. And my lord, most curiously, my lord, your lordship was pleased to direct on 3rd of May. My lord, CSC raised the bill on 10th of May. My client deposited the fee on 10th of May itself. My lord, on 13th, they made an application before the CSC authority allow us to shift. On 15th, this application was filed.
Allow us to shift.
And on 15th, this writ application was filed. My lord, since all these points were never raised before the district magistrate, since December, they chose not to challenge the order of the district magistrate. My lord, when my client already paid the money, my lord, all running and everything started. My lord, only to circumvent your lordship's order
Sir,
and
Mr.
to
Ryan,
frustrate.
I'll impose costs on
Yes,
you.
my lord. Page 38, my lord, can you turn to page 38? This initial application filed sometimes in 25th November 2021.
Why didn't you point it out to the district magistrate when the order was passed?
District magistrate on the basis, my lord, even lordship kindly
My
consider
lord,
the
kindly seize these
Wait,
documents.
you cannot argue both together. He's answering your query.
Now, my lord, kindly turn to page 41.
Yes, 41.
Your lordship will find this is a person to my application. This is 2nd December 2021. with reference to your application received.
You
through
were
an-
given notice of the writ petition, you did not point out before the writ court, before the
That is
district
because
magistrate, you did not point
The
out.
district magistrate, my lord, I have objection raised before the district magistrate, your lord shall find that is at page 40, prior to that, page 47.
Page 57 is the order of the district
Yes,
magistrate.
page
which was
47, my lord.
No, page 57 is the order of the district magistrate which was implemented.
Yes.
Show me anything from that order that you have placed this, that an application is pending, whatever. How could you make an application for recall of that order prior to the order being passed?
No, prior to that, my lord, I have made the representation before the
Whatever,
district-
that got merged into this.
Yes, after that's why, my lord, after passing of the order, my lord, can turn to page 77. This is on 23rd March. 26th April. Sorry, my lord. Page 77, my lord, got it? District engineer. And next is my
bill.
District engineer.
This is page 77. Bill.
Writ petition, my lord, I am relying upon the writ petition subject to question.
Writ petition.
Yes, yes, yes.
Page 70.
তারপরে আরেকটা order ছিল।
সেটাই তো কথা।
Yes.
And this is a certain district engineer to whom we have also applied for that it should be transferred into my, after passing of the order passed by the district magistrate. This is the application was filed. This is on 26th March, April 2023.
District engineer.
District engineer.
Yes. So what power does he have after district magistrate's order?
District magistrate, based on the fact, my lord, if you lordship kindly consider district magistrate, page 69. Page 69, my lord, can turn to page 69.
Which order? Dated?
Dated 23rd March 2023, later dated. I have expressed what is my difficulty because it is made to the district engineer, my lord.
Page 69.
Yes, well, this is also to the district engineer. It is on a wrong conception it was given, but it was given for the purpose of shifting of this meter. Because they are the authority so the this report, these applications were filed.
This is a patently malafide attempt, sir. Just to bypass the order of the court. No.
That's why
You're trying to obviate the order of the process of court. This patent content should be
this is
content.
the existing house is there. My lord, page 71, the existing condition of my meter room.
No, I'll reject with costs, sir. I act order need.
Page
But
73 is
petition-
the construction which I have made.
Very well. Rightly so.
That too on a
Writ
dispute
petition
order.
table, huh? 13. WPA such and such. আচ্ছা একই অর্ডারে দুটো হবে উপরে হচ্ছে রিট পিটিশনটা আর ক্যান ইন কানেকশন উইথ আগের রিট পিটিশনটা উপরে একদম উপরে হবে এই রিট পিটিশনটার নাম্বার তার উপরে ক্যান ওয়ান অফ সাচ এন্ড সাচ ক্যাপশনটা এইভাবে হবে ওভারঅল ক্যাপশন হবে ক্যান ওয়ান অফ সাচ এন্ড সাচ তার তলা হচ্ছে ক্যানটা যে রিট পিটিশনের কানেকশনে আগেরটা ইন সাচ এন্ড সাচ তার নিচে হচ্ছে নতুন রিট পিটিশনটা যেটা হয়ে গেল এটা ওভারঅল উপরে ইয়ে হবে হেডিং হবে তারপর প্রথম ক্যাপশনটা হবে ক্যান ওয়ানটা ইন সাচ এন্ড সাচ সাব হেডিং আর কি সেকেন্ড সাব হেডিং হবে আগেরটা হয়ে যাওয়ার পরে এই 13 এর WPA যেটা নতুনটা 1204 মানে নতুনটা যেটা 1204 হ্যাঁ এটা হচ্ছে সেকেন্ড সাব হেডিং আর উপরে যেরকম বললাম the present writ petition has been filed by the applicant in the review application which has been dismissed just now. Full stop next para. Learned counsel for the petitioner argues that after the district magistrate *s order dated December 23, 2022, comma, on the basis of which the order sought to be recalled in the earlier matter was passed, comma, the petitioner made two representations before the district engineer, comma, Southern District, comma, CSC Limited, comma, to shift the electricity line. Full stop. Next para. However, comma, it is seen from the chronology of events, comma, as rightly pointed out by learned counsel for the private respondent, comma, that the order of this court in WPA 10294 of 2023 was passed on May 3, 2023, comma, directing implementation of the order of the district magistrate dated December 23, 2022. Full stop. Next para. Although the petitioner seeks to submit that prior to December 23, 2022, comma, certain applications had been filed by the petitioner, comma, the same, comma, obviously, comma, merged with the order dated December 23, 2022 of the district magistrate. Full stop. Moreover, comma, there is no indication in the order of the district magistrate dated December 23, 2022 to the effect that the present writ petitioner had even pointed out the pendency of any earlier application. Full stop. Next para. After the district magistrate apostrophes order stood final, comma, WPA 10294 of 2023 was filed by the present private respondent, comma, where the present writ petitioners were very much parties. Full stop. Next para. However, comma, the writ petitioners, comma, despite several notices, comma, chose to abstain from the hearing of the writ petition when the same was ultimately taken up. Full stop. Consequentially, comma, upon consideration of the entire materials on record, comma, the order dated May 3, 2023 was passed. Full stop. Subsequently, on May 10, 2023, comma, the CSC Limited raised a quotation, comma, on which date itself the present private respondent complied with such quotation, with deposit of such quotation amount and other formalities, comma, upon which, comma, in the meantime, comma, the order dated May 3, 2023 has been implemented. Full stop. Next para. By way of the present writ petition, comma, the writ petitioner seeks to upset the appeal cart after the order dated May 3, 2023 of this court has attained finality, comma, without even preferring any appeal against the said order. Full stop. Both the orders in question, comma, being that of the magistrate and this court, comma, have since attained finality and have been implemented by the CSC Limited and the present private respondent. Full stop. At this juncture, comma, the present writ petition is evidently a malafide effort on the part of the writ petitioners to frustrate the process of court and the implementation of the orders of the district magistrate as well as of this court passed in WPA 10294 of 2023. Full stop. In such view of the matter, comma, the petitioners' malafide attempts cannot be given a premium by acceding to the prayers made by the petitioner. Full stop. Next para. In any event, comma, whatever contentions are sought to be raised by the petitioners are barred by the principle of res judicata as well as constructive res judicata in view of the categorical findings in the order dated May 3, 2023. Full stop. Hence, comma, WPA 12043 of 2023 is dismissed on contest on with costs of rupees 10,000 payable by the petitioners to the private respondents within a fortnight from date. Full stop. Urgent certificate copies.
Grateful.
Thank you.
Grateful. Item number 16 is also dismissed.
Both 13 and 16 are taken up together. Were taken up. 16 was decided first because that is the recall application.
Item 14.
But I'm appearing for the petition.
I'm paying for the licensing.
Adjournment.
No, my lord, I'm not paying. No, I'm paying for the licensing, my lord.
Oh, why are you so apologetic? Yes. License is the DVC.
Yes, my lord.
That's
That is why, my lord.
Yes. Finish the arguments in 5 minutes. Why not?
Yes.
Short matter.
Absolutely short. Actually, the question is, my lord, I had paid certain amount in advance of against a consumption of bill.
In advance?
In advance.
They claimed that?
No, my lord, I voluntarily.
Of your own, voluntarily, very good, yes.
DVC appropriated it against the area charges which has been stayed by the Honorable Division Bench. But the question here is whether it is a choice of the debtor or the creditor as regard vis-a-vis the appropriation of the money. Well, I'll rely on section 59 to 61 to just to give a background of the entire thing. What happened, initially challenge was made against the issue of multi-year tariff or single-year
With
tariff.
the 330.
Yes, ma'am.
Other matters are released. Yes. So that nobody can see your ignominy after this. I dismiss the matter.
Yes, madam.
Yes.
Madam, my
Apologetic, madam. Item 18, I was seeking to withdraw.
Yes, sir. Withdraw tomorrow.
Very.
After hearing this, it will definitely be in the list. Hey, 18 ta kalke rekho.
Order item 19.
Analogous আছে না কাল তো এমনিতেই থাকবে ওটা ওটা old matter specially fixed matter only 18 there are 3 matters connected
Three matters connected, but I am appearing in item 18, which I have instructions to withdraw.
Mr. Bandyopadhyay Malad is appearing in the.
I am appearing in 17, my lord. I don't have any instruction to withdraw. In fact, I.
let it appear after the vacation. I'll pass whatever
No,
they were
let it be tomorrow because, my lord, pursuant to liberty granted by your lordship, we had approached the division bench, my lord, by filing an application. The division bench observed that these applications cannot be entertained. We had to withdraw it. But until and unless your lordship protect our interest for 2 weeks, because the division bench order, my lord, goes against DVC. We are
tomorrow no detail here.
My lord, otherwise they will disconnect it in the meantime. Because that is for because the
tomorrow only new motions and whichever matters have been directed to
only thing this is related to recovery of area charge.
He has been.
So move your matter, Mr.
Lord,
Chopra. No
Lord,
indulgence.
I am appearing for item number 19. I wish to withdraw this matter, my lord, because I requested yesterday.
Yes, Mr. Chakravarti, I was hearing your matter in the midst of that these are happening. Yes.
My lord, the first.
No liberty to anybody.
Well,
Yes, you're arguing your matter. Please complete.
Yes, my lord. First round of litigation was in connection with the multi-year tariff or
Yes.
the single-year tariff, which my lord held that it can be a single-year tariff. The order was 70.
Yes, I remember that. So what is your present grievance?
Just there is some connection. Appeal was preferred against that order. Now, my lord, the second round of litigation had taken place. They had issued disconnection notice claiming the area charges, which my lord had against in favor of the consumer, saying those disconnection notices are bad because the orders of APTEL will be applicable to these consumers also. Now, that was a DVC preferred appeal against that order. In the meantime, only one thing had happened, my lord, as we had suffered disconnection due to my lord, a week time in a week, my lord knows that we did not work. We suffered a disconnection, although the petition was pending. My lord, some of the consumers had approached DVC. They were put to terms. Under coercion, they had given an undertaking that in installment they would have to pay the area charges. That issue of coercion is also challenged in a writ petition which is pending before my lord. Now, my lord, this both batches of writ petitions appeals were taken before the division bench. My lord, would kindly come to the order of the honorable division bench. Or may I come back tomorrow, my lord?
Mr. Bandyopadhyay cannot come back tomorrow. You also cannot come.
This is a motion, my lord. This is not.
Now I've understood the nature of the motion. Nature and character both.
My lord, 122.
Your? Oh yes, he is also motion, right?
They are all in motion, my lord.
No, they are suffering because of the specially fixed nature of the motion. Very well. This matter and 17, 18, those matters will appear tomorrow.
Lord, item 19 also, my lord, I wish to withdraw it. Yesterday also I requested you. Item 19.
28 টাও দিয়ে দাও কালকে। Tomorrow say 17, 18 যেটা বলে গেল ওইটা থাকবে 28 টা to be mentioned দিয়ে দেবে for extension only. Inform your other side, but কালকে টু বি মেনশনটা ওটা দেবে 1780 যেটা আছে থাকবে এই যেটা চলছে দিস উইল বি অন দ্য লিস্ট টুমরো ঠিক আছে আর নতুন কিছু
Item 19.
This
my lord.
tomorrow. You say another disconnection notice.
Item 19, my lord. Item 19, I wish to withdraw it, my lord. Yesterday also I prayed before your lordship, my lord, and your lordship.
Due to paucity of time, in view of the resolution of the bar, comma, the matter cannot be completed, the hearing cannot be completed at the motion stage today. Full stop. Accordingly, let the matter stand over till tomorrow. Tomorrow there will be 10:30.
No. My learned senior friend said, don't laugh at this. Anything can happen to all of us.
Do tomorrow anything.
I'm grateful.
ना तो ऑडियो खोलता है ना वीडियो खोलता है मैसेज को हमको कर रहा है
क्या मैसेज करते हैं
अभी क्या ना कि अदर मैटर्स आर रिलीज वो मैसेज तो उसने ही किया वो हमको भी सुन रहा है वो
ठीक जाओ बंद करो